Good morning, everyone. I'm going to wait just a minute while everyone gets hooked up, so please bear with me. Okay. Oops. Still a couple of people getting hooked up, so please wait for just one moment. All right. I think we have everybody hooked up who is going to hook up, and appreciate you all turning on your cameras in addition to having your audio when you muted when you're not speaking and on when you're speaking, of course. And we'll go forward. My name is Alan Lilly. I'm the presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office, and I will be presiding over this pre-hearing conference today. With me from my office staff are Amy Blunk, Kyle Woldridge, Nicole Mullen, and Skylar Anderson, and they, as always, do the logistics for these hearings, and I very much appreciate their assistance. I couldn't possibly run these hearings without their help. And they've developed quite a bit of experience over the last 2 years, and they're getting quite good at this, so I appreciate that. As stated on page 4 of the September 17, 2021 notice of second pre-hearing conference and public hearing, which incidentally I'm just going to refer to as the hearing notice today. The Administrative Hearings Office has not ordered a court reporter for this pre-hearing conference, and also will not be ordering a court reporter for the hearing or the site visit in this matter. Just as a preliminary matter, I know Mr. Donlin, your office ordered a court reporter for the last pre-hearing conference. Have you ordered a court reporter for this pre-hearing conference today?
Thank you, Mr. Lilly. Not that I am aware of. Maybe I can ask Chris Sanders if he's aware of that.
No, we did not order one, Mr. Lilly, for this hearing. The recording actually had relatively decent transcription, and so we felt that that was sufficient for our purposes for the go forward hearings.
All right, thank you. And it doesn't appear that anyone else has ordered a court reporter either. As stated in the notice, we do not normally order court reporters for any of our proceedings. We look at the Zoom recording, video plus audio, as the official transcript of the proceedings, and we intend to do that for this proceeding as well, including for the hearing. Of course, any party may order a court reporter at that party's expense if they want to, and if we do receive, they can decide what to do with the transcript at that point. But if we do receive a transcript from a court reporter, we immediately put that into the public record, our hearing record for the matter. And then at that point, anybody can access it. We don't have any really alternative but to do that. So that's what we do. So I think most of you, but not all, participated in the last pre-hearing conference, which we had in August. So I'm going to just very briefly go over the procedures that I'll follow today. I will do most of the talking, and I'll call on people to speak. But if I haven't called on you and you have something you want to say, please either raise your hand, either electronically with the hand raising feature in Zoom or the old-fashioned way on the screen. Either one works fine. And I will try to pause from time to time so I can take questions or comments from people as we go forward. When you're not speaking, please keep your microphones on mute, and it looks like you all have done that. That avoids any feedback problems. And during the hearing, this conference today and the hearing, I do ask that we be formal. Please call me Mr. Lilly, and I'll call you Mr. or Ms. followed by your last name. Some of you I've worked with in the past, and I certainly knew you on a first name basis, but I think it's best if we just have the proceedings have that level of formality. This is not a court proceeding, so please do not use Your Honor for referring to me. So with that, I'm just going to go down the notices of intent to appear that have been filed for this second round of hearings. I prepared a list of the parties and people who have filed notices, and I'm going to just go down that and basically just do a roll call. And then, of course, I'll ask whether I've missed anyone at the end. So for the Division of Water Rights Prosecution Team, the notice listed Kenneth Petrozelli and John Prager as the attorneys. Mr. Petrozelli, would you like to enter your appearance this morning? You have to go off mute, though.
Yes, this is Kenneth Petrozelli appearing for the prosecution team.
All right, thank you, Mr. Petrozelli. And I do see Mr. Prager is on the Zoom list as well, so that will be fine. And then for BlueTriton, I have, excuse me, it's BlueTriton Brands, Inc. And for shorthand, I'm going to refer to that entity as BlueTriton today and probably during the rest of these proceedings. So the attorneys listed are Robert Donlin, Christopher Sanders, Shonda Grady, and Rita McGuire. Mr. Donlin, would you like to enter an appearance for yourself and the other attorneys?
Yes, thank you, Mr. Lilly. Robert Donlin for BlueTriton in this proceeding.
All right, thank you. And I do see that the other attorneys I've listed are all here as well. So good morning to all of you. For California Department of Fish and Wildlife, the notice of appearance said Nancy Murray and Kathleen Miller. Miss Miller, I see you. Unless I'm missing something, I don't see Miss Murray today. Would you like to enter an appearance?
Sure, and Miss Murray will not be joining us this morning. Kathleen Miller for the Department of Fish and Wildlife.
All right, thank you and good morning. And then for San Bernardino Valley Municipal Water District, the notice of intent to appear lists Meredith Nickel and Samuel Bivens. I see Ms. Nickel, you're here today. I don't think I see Mr. Bivens. Would you like to enter your appearance?
That's correct. Meredith Nickel on behalf of the San Bernardino Valley Municipal Water District, and Mr. Bivens will not be appearing today. Thank you.
Thank you and good morning. Let's see, Story of Stuff project. I have listed Rachel Doughty, and if I don't pronounce that right, please correct me, Jessica Taylor, Paul Kibble, and Michael Ohimi. Ms. Doughty, I see you are here today. Would you like to enter your appearance and list the other attorneys as well?
Sure. Good morning. My name is pronounced Doty. So I'm here on behalf.
Doty, excuse me, did you say Doty?
Doty, like bread dough with the TY on the end.
Okay, thank you. I will try to get that right. Excuse me, go ahead.
You did a good job. Some people have butchered in much more embarrassing ways. Jessica Taylor is also here on behalf of Story of Stuff. And then Michael Ohini is here. He is a client, not an attorney.
Okay, thank you very much. And then Sierra Club, Lauren Silver filed a notice of intent to appear. I don't see Mr. Silver. Is anybody here for the Sierra Club today?
I'm not here officially for the Sierra Club, but we are coordinating this Lisa Belenke with the Center for Biological Diversity. And I'm not positive. I don't believe that Larry Silver could make it today, but I will certainly be coordinating with him.
All right, so Ms. Belenke, why don't we just go forward with you? I have you and Ross. Oh, there's Mr. Silver. You have appeared.
Ah, there he is. See?
So why don't you go off mute and enter your appearance, please?
Yes, Larry Silver, California Environmental Law Project.
All right, and is your client today the Sierra Club, Mr. Silver?
Yes.
All right, thank you, Mr. Silver. Good morning. So now we'll go to Center for Biological Diversity. I have Ross Middlemiss and Lisa Belenke. Ms. Belenke, you've already spoken. I don't see Mr. Middlemiss. Would you like to enter the appearance for Center for Biological Diversity today?
Yes, Lisa Belenke on behalf of the Center for Biological Diversity.
All right, thank you and good morning. And then I have Hugh Belecki is listed as appearing for himself. I don't think I see him here. Mr. Belecki, are you on today? Bielecki, I guess. All right, well, we will move on then. And Steve Lowe, I do see you. Mr. Lowe, would you like to enter your appearance this morning?
Yes, good morning. This is Steve Lowe, and I'm here representing myself.
Great. Well, thank you very much. It's great to have you, and good morning. And then Amanda Fry, please enter your appearance.
Hi, good morning. Amanda Fry. I'm resident of California and citizen of the United States.
All right, thank you. It's good morning. It's good to have you here as well. And then I do have we got an appearance, a notice of intent to appear from Anthony Serrano. And I don't think I see him listed here. Is Mr. Serrano, are you on this morning? All right, and just to clarify, even if people do not appear today, they still may, if they filed a notice of intent to appear, they certainly still may appear during the hearing. We did, on the last round of NOIs, receive NOIs from the following people who said they just intended to submit policy statements, but not to participate in the hearing process. I believe we have included them all in our service list and will continue to do so. But I don't see representatives, I don't think of any of them here today. But that's California Water Association, Northern California Water Association, Association for California Water Agencies, League of Women Voters in the San Bernardino area, Marianne Dickinson, and Henry Fry. So we certainly will continue to keep them on the service list, and we'll consider their policy statements during these proceedings. Just so all of you know, I'm sure you do, but this hearing is also being live streamed by YouTube Live. And people certainly, any member of the public who's interested, certainly may follow the hearing that way. They can't appear or speak if they're on YouTube Live, but they can follow the proceedings. And we do post a recording, the YouTube recording we post on our webpage on the State Water Board's website after the proceeding. In addition, the Zoom recording we add to the record on in the AHO FTP folder for this matter. So, and then I did receive in the last round an attorney from the United States Department of Agriculture Forest Service asking for that he and two members of his staff be included in the service list, and we have done that and will continue to do that. So have I missed anybody today who would like to either enter an appearance or state that they want to be included on the service list or otherwise to participate in this proceeding? All right, thank you. So just a couple of matters I would like to emphasize. I know I talked about these before, and all of you have been very good about this, so this is not in any way meant as a criticism. But on pages 10 and 11 of our November 7 hearing notice, we talk about ex parte communications. And one of the things I have tried to do since I set up the Administrative Hearings Office is avoid ex parte communications, even on simple matters like I'm having trouble uploading my exhibits to the AHO FTP folder that you've assigned to me. I know it's more burdensome. A lot of times it would be easier to just pick up the phone and call one of us. First of all, we're usually not in the office because we're still working remotely for COVID reasons. But secondly, and more important, my experience is sometimes those conversations can sort of deviate or divulge into, I'll say, into more substantive conversations. And in fairness to all the parties, I just like to avoid those. And we do have email. It's very easy. You've all signed up to be on the email list. So if you're communicating with us for any reason, just send an email to the AHO email address with CCs to all the other parties. They're probably going to get really bored reading about if you have problems uploading your exhibits, but I'd rather just have full disclosure and no question about that with ex parte communications. And if something more important comes up and we need to schedule another conference call like this one, we can do that. Since we don't have to travel, it's not that hard to spend a few minutes on one of these conferences if we need to. So after this conference, I will prepare and my office will circulate a second pre-hearing conference order with any updates to the service list that are necessary. I think we did receive from the Stodia request for some address changes for Story of the Stuff project. and we will try to continue to update our service list as necessary. So anyway, that's all I have to say on that. We do have mailing addresses listed on the service list in case paper mailings are necessary, but normally they are not. Now, having said that about ex parte communications, I do want to emphasize you are all free to talk with each other, any and all of you, with any and all of the other people at any time regarding any matter, whether it's settlement, logistics, and I am going to mention the site visit and all that. And there's no prohibition on ex parte rules about that. So just so we're clear, feel free to pick up the phone and call anybody else who's on this call today who's not in my office, or shoot emails back and forth and do any communications you think are necessary or appropriate or that you just want to. But please just do not include the Administrative Hearings Office or anyone in the State Water Resources Control Board outside of the prosecution team in those communications. So with that, I'm going to pause before I get to the pre-hearing conference issues. Does anyone have any questions or comments about what I've said so far? All right, hearing none, we will go forward. The November 17 hearing notice did list 4 pre-hearing conference issues. And then 2 other things have come up. One is on December 2nd, the Administrative Hearings Office received the prosecution team's motion to quash BlueTriton's November 30th subpoena ducis tecum. So we need to talk about a briefing schedule for that. And I think there was one other thing that I added to my list here. Just let me make sure. I'll tell you when we get there. Oh, yes, I do want to talk about the groundwater extraction reports that have been filed for this matter. So I'm going to just go down the list here and we'll go through one by one and do this as efficiently as possible. I did receive, they were optional and a lot of parties did not file them, but I did receive second pre-hearing conference statements from the Division of Water Rights prosecution team and from BlueTriton. Did anybody else file a second pre-hearing conference statement? Just wanted to make sure I didn't miss it. Ms. Belenke, please go ahead, unmute and tell me what's going on.
Yes, we did file a second pre-hearing. No, not a conference statement. We filed the other form. I'm sorry, I was mixing the 2 up.
Notice of intent to appear.
Okay.
Yeah, we did receive that from you, absolutely.
Okay.
Yeah, and the pre-hearing conference statements were not required, so don't worry. Everyone's in order so far. Okay, so I'm going to go through the issues in the order they were listed on the notice and then talk about the supplemental issues. Issue 1 was, should the hearing officer change any of the deadlines for submitting exhibits and testimony or the hearing dates listed in the notice or make any other changes to the hearing schedule? And just by way of reference, the November 17 hearing notice on page 6 has a schedule with the various hearing days, the site visit dates, and the filing deadlines. So on this issue, BlueTriton has asked for leave to submit additional exhibits and written proposed testimony and potentially to amend its NOI witness list if necessary to respond to new information or arguments made by the prosecution team and to make these supplemental submittals by December 30th. So Mr. Donlin, would you like to add any comments regarding this issue? I mean, it's covered pretty well in your pre-hearing conference statement, but I'd just like to know if you'd like to add anything else.
We don't need to add anything, Mr. Lilly. Thank you. I will say that the reason we made this request is that we discovered recently that we may not have our arms around the record in this proceeding. And I think that's one of the issues that hopefully we will get to today is the scope of the record for this proceeding so that we can adequately prepare our defense.
Okay, and have you, I know there's been communications, at least I have seen copies of communications between you and Mr. Petrozelli regarding your subpoena and the documents covered by that. But have you had any other discussions beyond that with Mr. Petrozelli? Again, don't divulge any settlement discussions, but have you had any discussions regarding these administrative record questions that you're raising now with him?
Yes, on November 29th, as stated in our pre-hearing conference statement and Mr. Sanders' declaration, we had a conference call with Mr. Petrozelli and some of his colleagues as directed by your, I believe, November 17th hearing notice around some redacted documents that were submitted to the prosecution back in, I believe, 2017. As part of that discussion, we did have a broader discussion about the hearing record, and it is described in Mr. Sanders' declaration. As part of that discussion, we were unable to determine whether we had all of the records that would be submitted by the state, the prosecution team in this matter. That was
Okay.
the only other conversation that we've had subsequent to your November 17th hearing notice.
All right, thank you. And I'm glad you're talking. That can definitely facilitate our pre-hearing process. So, Mr. Petrozelli, would you like to comment on both what Mr. Donlin has said today and also on the broader question of his request to have basically a second date for potentially supplemental exhibits and written proposed testimony? Please let me know what your thoughts are on that.
Well, I call it a pre-rebuttal, like skipping straight to rebuttal and then still getting a rebuttal. All of the parties are submitting all of their exhibits on the same day. That's how we always do it. And then you have an opportunity for rebuttal after you see all of that. And there's really no reason why they should have some special opportunity to amend their witness list and submissions. They've seen the substance of our case. It's in the report of investigation. It's in the draft cease and desist order. The report of investigation has an extensive list of references that have been posted to the website for many months. They sent us multiple Public Record Act requests. We responded to all of those requests and disclosed everything that they requested that was not privileged. And in this discussion on November 29th, they asked if there was anything new that would be going in the record that they hadn't already seen. And frankly, that was not what I had understood we were going to discuss. We were supposed to discuss your direction to talk about redacted documents, which I will probably discuss later. And we had also previously discussed the possibility of stipulating to the admission of certain documents, as may sometimes happen, to reduce duplicative submissions. But it turned into a pretty persistent line of questioning about what evidence we intended to submit. And I could definitely say that we were going to submit references to the report of investigation and the report of investigation and board orders and decisions that were cited. But there are a lot of documents. Just when you have the references to the report and board decisions, and speaking off the top of my head, I couldn't give them an exact answer, and I didn't want to give them an exact answer because I didn't want to give them a wrong answer. So they asked if there was anything new. I don't recall that they asked about documents that we had previously asserted privilege to. So I don't recall that specifically coming up. I only recall that they asked about anything new, and that seems to be consistent with the recollection from our other people who were also on the call. I said they would see our case and they would see our exhibits on January 17th when they're submitted with our case in chief. So
Okay.
I think it's I think their request for an opportunity to, amend their witness list and their testimony and their exhibit submissions is, pretty ridiculous. That's why we have rebuttal. It's kind of like they get a rebuttal right away, but it's better because they still get a rebuttal later. And it reduces the time that the rest of us have to prepare for cross-examination because they can change everything. We have to look at how all of their testimony changes, how their exhibits change. So, it advantages them and it hurts the rest of us. And their extended timeline happens over the course of, 2 significant holidays, actually 1. But,
They would have to work over Christmas and then you'd have to work over New Year's is the way it would work with their December 30th proposal.
There are fewer working days than it immediately appears because of the holidays.
Okay.
Yeah.
All right. So Mr. Petrozelli, I didn't ask this before, but you brought up well, first of all, on the November 29th call, excuse me, go ahead.
And let me say that, what they've asked for is not recently discovered. It's been the subject of prior Public Record Act requests. So it's nothing new. They could have made their request, 4 months ago in an APA subpoena, when this hearing was first noticed, but they made it last week and gave us, all of 5 days notice.
Okay, I think you're getting into the subpoena, which we will talk about separately.
Well, I only want to make the point that this isn't new. This isn't something they recently discovered as they've
Okay.
characterized.
So first of all, Mr. Petrozelli, on the November 29 conference call, were representatives of any of the other parties participating besides the prosecution team and BlueTriton?
No.
Okay, and that's fine. It's not a requirement. As long as my office is not involved. And second, you mentioned the redacted documents. Were you and Mr. Donlin able to reach resolution on the submission of redacted or unredacted documents? I know we talked about this at the last pre-hearing conference, and I didn't see anything in any of the papers on that, so I wondered whether that issue is.
So there are 3. There are 2 that relate to the respondent. I don't have the citations, the ROI citations for those documents immediately handy. I can provide them if you like. But that was correspondence where the respondent asserted trade secrets as to certain content. So that content was redacted when it was released in response to Public Record Act requests and for the report of investigation. And my concern in raising that issue in the first pre-hearing conference was how to address the possibility of somebody objecting to those redactions in the course of the hearing. And that was what we discussed. And I believe, and Mr. Donlin can perhaps supplement or correct my answer, I believe what we decided was that if there is an objection, if there is a request, we can resolve that much as we would any other assertion of privilege.
I mean, if there's an objection to submitting a redacted document, if there's an objection to the redactions, then we can address it during the hearing. And that probably I will let you talk, Mr. Donlin, but that probably makes sense because I certainly can't rule on something in the abstract when I haven't even seen the redacted document. As I mentioned in the November 17 hearing notice, I just want to make sure we don't have any ex parte issues. I mean, if you submit a redacted document, everybody's fine with that, that's great. If somebody thinks we need to see some of the redactions, then we'll have to talk about a process. If necessary, we can do a protective order, but it has to be so that all parties get the same thing that I get. It just doesn't work for my office to have information, even redactions, that the other parties do not have. So, but it doesn't sound like we're going to have a problem with that. So Mr. Donlin, I'm going to ask you to just respond to Mr. Petrozelli briefly, if you can. I think your position is pretty clear, and then I'll ask for the other parties' comments. But Mr. Donlin, do you have any response at this point?
Thank you, Mr. Lilly. I'll let ask Ms. McGuire to respond to the redacted documents. Ms. McGuire participated in the call on November 29th. With respect to our request for leave to amend our notices of intent, we were pretty clear about what the scope of this hearing would be when we saw your ruling on our motion to dismiss and the extraneous issues that the state had and other parties had proposed to include in this proceeding. It was part of the conversation on November 29th to raise some question about whether we had the same understanding as the prosecution team about the scope of the record and the scope of this proceeding. And then subsequent to that, of course, when notices of intent were submitted last week, there are parties that intend to put in information that has not been part of the record. So we take Mr. Petrozelli at his word that there's no significant new information. And if there isn't, then we have no intent of modifying our notice of intent in our exhibit list. But if there is new information and new lines of argument, and that's allowed to come into this proceeding, we deserve the opportunity to amend our submittals.
All right. Does anybody else have any comments on this issue before I give my comments? I do see some hands up. So Ms. McGuire, let's start with you because Mr. Donlin did mention you were going to address the trade secret issues. So please go ahead.
Thank you, Mr. Lilly. My response is directed simply at the redacted documents. That correspondence occurred in 2016, and it involved not only written documentation, but videos and photographs of the facilities in Strawberry Canyon. The vast majority of those items were not objected to by now BlueTriton. There's only a small quantity of photographs and perhaps a segment of a video. It was not simply trade secret, but it was also safety concerns for our employees and others. The response was provided by Mr. Petrozelli on August 16th of 2016, in which he agreed that some of those were entitled to protection and remain redacted. And to date, I'm unaware of any objections to his findings. We would simply request that we maintain the status quo of those documents per that August 16th letter.
All right, thank you, Ms. McGuire. So Mr. Lowe, your hand is up. What would you like to say? And please take your hand down when you're spoken after. Thank you, Ms. McGuire, but go ahead, Mr. Lowe. If we go off mute so we can hear you.
I was just going to say that we're all having to meet those same deadlines, and it's difficult. And some of us really do have new information that we're trying to get in to. So if BlueTriton is granted the ability to do it over again and have a longer time, then everybody should be given exactly the same treatment. It shouldn't be just as special for them.
All right, thank you, Mr. Lowe. Ms. Fry, your hand is up. Please go ahead.
I ask you to deny the request to extend the deadline. As Mr. Lowe said, we, as private citizens, have spent a great deal of time and energy doing our research, and they've had plenty of time. This is nothing new. I've been doing 7 years of research. This has been going on for at least 7 years. And as far as the redacted documents, most of those have been out in the public anyway. So there seems to be nothing that would to hide. This is Strawberry Canyon is on public land. And this is public land that belongs to each of us as United States citizens.
All right,
Thank you.
Thank you, Ms. Fry. And Mr. Petrozelli, I see your hand is up. Please go ahead.
Yeah, I want to say that, you know, I can't speak, and neither can the prosecution speak to what issues other parties might raise or what exhibits or evidence they might choose to submit. You know, we have no knowledge of that. You know, they're acting on their own, and you know, if something comes in that's outside the scope of, you know, the noticed issues, you know, there's always the opportunity for, you know, relevance objections. There's the possibility for rebuttal. So it is, I will say that it has not been uncommon in hearings and enforcement hearings for new information to come out. I've been in enforcement hearings where hearing respondents have even admitted to, you know, an entirely new set of potential violations that were not in the initial pleading. So, you know, hearings can take surprising turns.
All right. I think that's probably pretty clear based on my experience as well. So thank you. I will address this issue in my pre-hearing conference ruling. I will just say, first of all, Mr. Lowe and Ms. Fry, I do appreciate your comments about the challenges of private citizens participating in a hearing like this and meeting the same deadlines as everyone else with limited resources. And I certainly am going to be very interested to hear from both of you, because I know both of you have many years experience in the area, which is very valuable. So I'm looking forward to that. I don't know how it'll affect the decision making, but certainly that type of information is very useful for this hearing. I will say, though, I think Mr. Donlin has a good point on the question of whether or not the prosecution team's case, I'll just say, which is, of course, they have to put on the initial case. And if that goes beyond what's in the draft cease and desist order and their report of investigation, which frankly are very extensive, but if there's something that really is beyond both of those docs, which are effectively the charging documents in this matter, and all of the records that the prosecution team has already produced to BlueTriton, and I don't know whether this is possible or not. Mr. Petrozelli, you know, is not committing, and that's fine, but it doesn't sound like there's anything else. But if there's some new document that brings up a totally new argument or issue or fact that has not been addressed in any of the prosecution team's documents before, I think it does make sense for BlueTriton to be able to respond to that. And frankly, I'd rather get that in early before the hearing starts, because that just allows the hearing to be more efficient. And of course, then all parties still will have the opportunities for rebuttal. So my inclination is to have a very limited, basically allowance for BlueTriton to submit potentially to submit additional proposed hearing testimony and exhibits. But I will say, Mr. Donlin, if you decide to do that, I'm going to require that you very clearly state what this is responding to, what new information that the prosecution team has submitted with its exhibits and testimony in December, I forget the date, I think it's December 17, that was not in the draft CDO or the ROI, and that you did not previously have. If there really is something new and you have a chance, I'll call it pre-rebuttal. That's fine. I will allow that, but it's going to be pretty darn limited. And of course, beyond that, all parties, BlueTriton prosecution team and all other parties will have the opportunity for full rebuttal down the road. But frankly, it just makes my hearing process go more efficiently if we get that out early, if effectively the charging documents or charges have been expanded beyond the charging documents. So that's my inclination. It's going to be limited and require justification. So, Ms. Fry, I do see your hand has been up, so please go ahead if you have something else to add.
I believe that if you are going to allow BlueTriton to, amend exhibits and their witness list, then you should allow all of us to the same opportunity.
Okay, and just so we're clear, this is not amendments, this is supplements for the very limited purpose of responding to new charges that the prosecution team has made against BlueTriton. And
I
so
would like that same opportunity to submit supplemental evidence.
Yeah, and you will and you and all the other parties will during the rebuttal phase. Absolutely. This is a limited exception because BlueTriton is in a different position than the other parties, because the prosecution team has brought charges against BlueTriton. So that's why. But don't get me wrong. You and all other parties will have a full opportunity to rebut everything that anyone else has submitted during the rebuttal phase. So, and Mr. Petrozelli, your hand is up now, so please go ahead. But go off mute.
Well, the other parties get one rebuttal. BlueTriton potentially has two. I will say that it is not uncommon that parties seek to submit late exhibits for one reason or another. And usually when they do, they need to demonstrate a good reason for doing so. You have perhaps suggested one, but this happens. And I believe that should you grant BlueTriton's request, it should be very narrow, and they should definitely have to demonstrate a good reason for not having submitted that testimony or evidence with their initial case in chief. They should have to show that they were not aware of those issues. They should have to show they were not aware of those facts. They should have to show they were unable to previously submit that information.
I think I agree with you on all points, Mr. Petrozelli. I think that's what I said.
And I believe that is similar to the kind of showing you would typically have to make in a board hearing if you wanted to submit some kind of late information. Okay,
well, I know we're all learning here about how this process is going to go forward, and we'll see. But just so we're clear, for rebuttal, first of all, and Ms. Fry, I understand where you're coming from, and if it looks like I'm giving BlueTriton special treatment, the answer is I'm giving them unique treatment, and that's because they're the entity that the charges have been brought against. But everyone will have a chance to rebut whatever anybody submitted during the first round. But Mr. Petrozelli, I'm completely in sympathy with what you're saying. Rebuttal is not an opportunity to basically reopen cases in chief and put on more stuff that you forgot about before. I normally require, and certainly plan to require, that any rebuttal testimony has to explain what it's rebutting. And that I normally have that requirement, and certainly intend to here. You have to list the specific witness and testimony or exhibits and say, this rebuttal is in response to this exhibit or testimony that party A, party B submitted during the first round, during the cases in chief. So I think we've covered this pretty well. As I say, I will put this out in the written ruling, but I think Mr. Donlin and BlueTriton have given grounds for a very narrow exception that they may or may not be able to demonstrate applies here. So Ms. Doty, please go ahead. I'm sorry if I didn't see your hand before. Your hand is right about, blends in with the background on your wall. Please go ahead.
Because it occurred to me when you were speaking just then that there's the other issue that BlueTriton, my understanding is that they had the option but declined to exercise it to perform discovery on other parties. And we've received no discovery from them. So they could classify all of our exhibits as new material against which they want to supplement the record. So I just want to be clear that what you're talking about is new charges, entirely new charges by the Water Board, which we're not anticipating any of. And that's what evidence would be submitted against, not just, we have a historic document that we found, not new, but that they haven't seen before. I imagine we'll have some of those.
I agree completely with what you just said. This is just for effectively new charges brought by the prosecution team. If BlueTriton or any other party says, hey, Store of the Stuff Project just submitted this evidence and I want to respond to that, then they can do that during rebuttal. But that's during the regular rebuttal phase, not during this preliminary rebuttal. This preliminary rebuttal is limited solely to documents that can be characterized as new charges by the prosecution. So, all right, I think we've just about beaten this issue up, but go ahead, Mr. Petrozelli.
I can definitely say that we don't anticipate bringing new charges, and anything that comes in on rebuttal, again, it's like any other piece of evidence, you have to make an offer of proof to show that it's relevant. You have to show that it's within the scope of the issues, and other parties can object. So
I appreciate those comments. I have a feeling we're going to, well, I don't know for sure, but my instinct is based on what you just said, that BlueTriton may conclude that there is nothing to supplemental to submit on December 30th, based on what you just said. But we will see. I'm going to leave that door open in case they think there's something that you have raised that's new. I mean, as I said before, your report of investigation and draft cease and desist order and supporting documents are very detailed and very thorough. So, I don't know what you're going to do, but it's a little hard to contemplate that there's something totally new that you're going to raise and submit on December 17th that's not covered in those other very detailed documents. But let's wait and see, and we'll go forward. I think we have a process, and I certainly appreciate everyone's comments. And certainly if somebody feels that they've been slighted by this process and what, the supplemental submittals, we can talk about that during the hearing. But as I say, we do all have the backup that everyone will be able to rebut what is there. At the end of the day, what I want is to get all relevant evidence into the record so that I and my colleagues in my office can review that and can make the best informed decision we can. And this is not a game where we try to prevent people from submitting evidence. This is trying to get to the truth of the matter. And this is a very complicated proceeding, very, very complicated factual and legal issues. So we want to have a process that will get all the information we need into the record. So with that, I'm going to go forward to issue number 2 from the pre-hearing conference statement. I do appreciate all your patience with me bearing with me on this. Issue number 2 stated, what time limits should the hearing officer set for oral policy statements and oral summaries of written statements and parties' opening statements, oral summaries of written testimony, cross-examination, and rebuttal testimony? On page 20 of the November 17 hearing notice, it states that parties will be given 5 minutes to make opening statements. I'm not going to talk about policy statements because that doesn't apply to any of you here because you're all parties. 45 minutes for their witnesses to summarize their written proposed testimony, and 45 minutes for cross-examination for each witness or panel of witnesses. And I'm also not going to get into rebuttal. We'll cover that down the road after we've had the first round of hearings. One thing I would like to emphasize, particularly for those of you who have not participated in State Water Resources Control Board water right hearings before, I know some of you have and some of you have not. And this, I know our hearing notice is very detailed, but please read it. It's all really important stuff. And particularly on page 20, it says that witnesses must provide their written proposed testimony, and then on direct examination may only provide summaries of their testimony. We really mean it. And that means that this is normally something I strictly enforce. So summaries mean summaries. You can't just sort of start talking about new things that you thought of after you submitted your written testimony. That's one of the reasons I really encourage parties to have summary slides, because that helps basically summarize your written testimony. I have seen parties try to go on and on beyond that. And frankly, the reason I strictly enforce that is in fairness to the other parties. It really would not be fair to, if party A strictly follows the rules and then party B has witnesses that just go on and on and on beyond their written proposed testimony. That's just not fair to party A. Then they're surprised. It's harder for them to prepare their cross-examination and so forth. So please make sure that each of your witnesses' written proposed testimony, or if you're appearing on your own behalf, your written proposed testimony includes everything the witness, or you if you're the witness, wants to testify about on direct examination. We really mean it. Now, related to that is the question of how long does it take to, how long will I allow parties to summarize their written testimony? And again, I want to establish that context here. A summary is a summary. I mean, I will read everything that is submitted before the hearing starts. So in some ways, there's no need for you to have any oral summary at all of your direct testimony. But we've found that it does help the process to give people an opportunity to sort of give a little life to what they've already submitted in writing. And frankly, 45 minutes is a lot of time for summary, but I've decided to do that so that everyone really has a chance to, as I say, to present orally with feeling, with inflection and personal testimony, what your summary is. But it's still going to be just a summary, and it's going to be limited to 45 minutes. So, Mr. Donlin, your pre-hearing conference asked for some leeway from the 45-minute limit. I think I've sort of expressed my feelings on this, but is there anything you would like to add about that?
No, I'd only like to add, Mr. Lilly, that we do intend and plan to stay within the 45-minute timeline if we submit direct testimony. We do have numerous parties, in addition to the prosecution, that intend to submit testimony against BlueTriton. And it may be worth the hearing officer's time to hear a more robust summary from our witnesses. And we just would like some accommodation if it puts us up against the 45-minute limit.
Okay, well, I have noted your request, and I hope I'm sure you've heard my admonition that I do understand to some extent. You probably feel like it's us against them. I don't know whether there are any parties that will be supporting BlueTriton. Of course, you're very able to represent BlueTriton. There's no question about that. But I do understand there might be some feeling, hey, we get 45 minutes, and then there are 6 other parties all opposing BlueTriton, and each of them gets 45 minutes. So we'll go with the flow on that. But I do want to really limit these direct testimonies to summaries. I think 45 minutes is a fair amount of time. particularly if you're organized with slides, and I'm sure you and your witnesses will be. So let's do that, and I won't say it's ironclad, but it's pretty darn close to that for time. Now, the 45 minutes for cross-examination is a different issue because, first of all, sometimes cross-examination takes longer if a witness is rambling with his or her answers or evades. Not that witnesses would ever do this, but sometimes witnesses have responses that I'll just say aren't directly on point and may go on. And frankly, there may also be materials that need to be covered that take more than 45 minutes. So that's the nominal time, but I do have more leeway, I think, just to provide due process of law to all parties. We have to have some additional leeway on cross-examination because you can't prepare that in writing ahead of time. But that's going to be my goal for cross-ex as well. So does anyone else, I do see some hands up, and then I'll ask if anyone else has any comments. So Ms. McGuire, your hand is up. Why don't you go first?
Thank you, Mr. Lilly. My question does go to cross-examination. As I understand your order, you're saying that each cross-examination is initially limited to 45 minutes. My question goes to, is that 45 minutes per witness or per examining party? There are actually 10 parties participating in this proceeding, 9 of whom I think are opposed to BlueTriton in one fashion or another. If our witnesses are exposed to 45 minutes of cross-examination by each of these parties, that moves beyond the concept of cross-examination and could be described as torture. So I would appreciate the clarification.
All right, well, thank you. We don't want torture, if that's possible over through Zoom, but we definitely don't want that. And I understand, I'll just say I cannot imagine that 9 other parties all are going to have 45 minutes each of cross-examination of BlueTriton's witnesses. But I'll just say, I don't know how it would be fair for me to limit some parties to shorter time than other parties. But having said that, I will enforce the prohibition on duplicative questioning. I mean, if party, let's say, if party A's attorney has asked BlueTriton witnesses about some things, and then party B's attorney wants to ask the same questions or questions on the same topics, I will limit that. And I think that will go a long way toward basically preventing the torture that you talk about. Because whatever 9 times 45 minutes is, that's a lot of cross-examination, and I understand. And frankly, that's one of the reasons we have the written proposed testimony requirement, because parties then can get that and can prepare what should be much more succinct cross-examination questions than if they just heard the testimony for the first time during the hearing. So I'm not going to give you an answer about changing the time limits, but I do appreciate what you're saying, and we will be sensitive to that. And that's not just for, BlueTriton's witnesses, that's for all the parties' witnesses. So nominally 45 minutes, which frankly is a lot of time, but subject to limitations on avoiding duplicative testimony.
And Mr. Lilly, if I could add one more observation, I think much of it turns on how strictly you impose the limitation to the direct testimony or the written testimony and limit it specifically to the issue before the hearing office, which is the unauthorized diversion of water under the jurisdiction of the board. A number of these parties only provided public comments to the State Water Resources Control Board on the public trust doctrine. So the question in our minds is, how are they going to participate in a hearing that's substantially narrowed to one fundamental issue?
Okay, and let me just be clear. The State Water Board's regulations, which track the government code, I believe it's section 11513, but I'm not positive, state that cross-examination is not limited to what was covered on direct examination. That's a statutory requirement that we have to follow. So obviously we do. But having said that, we certainly, and I will certainly enforce the limitation on cross-examination to examination that's relevant to the issues that we have specified for the hearing, which I think will address your concern, at least to some extent. So, okay, I'm going to go on. While we're on BlueTriton, Mr. Donlin, your hand is up, and then I'll come over to Mr. Lowe and Ms. Doty. But Mr. Donlin, go ahead.
Thank you, Mr. Lilly. On that last point that you made, your post-hearing order also address friendly cross-examination?
Why don't you elaborate what your concern is?
Well, in the prior proceedings before the hearing office that I've been involved in, the hearing officer has admonished the parties not to engage in friendly cross-examination in order to elicit testimony that should have been in the case in chief.
Right, well, there's no way I can rule on that today. I understand the issue, and we will have to just deal with that as we go forward. I guess what your concern is that parties potentially could ask the prosecution team to elaborate on their testimony in ways that goes beyond what's submitted in writing. I think is that what you're alluding to by friendly cross-examination?
That's one example, Mr. Lilly.
Yeah, okay, and there may be others, but we will just have to deal with that as we go forward. I mean, I certainly am familiar with the practice. It's not something that's normally appropriate. I agree with you on that, but there may be some nuances into exactly what is appropriate cross-examination and what is not. So we're going to have to deal with that as when we get to the hearing and during the hearing. So thank you. So Ms. Doty, I'll go to you. Your hand is up.
Thank you. I have a question about, there are a number of unrepresented parties who expect to testify, and I wonder how you envision defense of cross-examination of those folks. And I'm guessing a related issue, which maybe I'll address later or now, is how they will do their direct, if that will just be a narrative format. So.
Okay, so it's a good question. Thank you. For unrepresented parties who are appearing basically by themselves without an attorney to represent them, that certainly is allowed, and we welcome, frankly, a testimony from interested parties. They are under oath. They are subject to the same requirement to summarize their testimony. Usually I can help them out by saying, Mr. X or Miss Y, please summarize your written testimony, and then they can go. Of course, they're under oath. So I don't think the direct testimony is a logistical problem for an unrepresented party. Cross-examination potentially could be an issue. And if I think a question is inappropriate cross-examination, I certainly will speak up. I can effectively object to that. And other parties' attorneys can as well. It's a little hard for an unrepresented party to object while he or she is actually giving testimony. If something is really outrageous, they may be able to, but I think we just have to go with the flow. This is something we're fairly familiar with the water board proceeding, so I think we can work that through, but I appreciate your raising the question. All right, so Mr. Lowe, your hand is up. Please go ahead. Whoops, you're on mute. You were off and now you're back on mute, so try one more time. There you go.
Can you hear me? Okay.
Yes, go ahead.
This is all new to me, so I'm trying to keep up with you guys, and it's really, really hard. Just even reading the 28 pages of instructions was hard for me. But so I was understanding that the proposed testimony that we needed to submit by the 17th, which is not very long away, was what we thought we were going to talk about. But I thought we had a chance between the 17th of December and the actual hearing to build our case more, to come up with data that was still out there that we're still reviewing and those kind of things. So I didn't get the feeling that 17th had to be everything we could possibly say. And then on the actual hearing, we could only summarize that. I wish we have time to still do some work on our case between the 17th of December and the actual hearing.
All right, well, I'm sorry if that wasn't clear. I I guess I understand the hearing notice is detailed, and it certainly is something that attorneys are more familiar with than people who are representing themselves who are not attorneys. But I guess I'll just say, I really do mean it, that yes, by the 17th, you need to submit what you plan to testify to. And if that includes data and other analysis, you need to get that in by the 17th. Now, having said that, that does not mean you have to submit by December 17th your responses to what other parties submit. If you see something in BlueTriton's exhibits or in the prosecution team's exhibits or in some other party's exhibits that you say, hey, wait a minute, I disagree with that, or I have data that refutes what they're saying, that's rebuttal. And that will be in the second round. So if you're rebutting or responding to someone else, you do not need to submit that by the 17th. But just for what you want to say, what evidence you want to present, you do need to get all of that in by the 17th. And, again, I realize that may be a burden, but that's why I got the notice out as early as I did, to try to give as much advance warning. And, I understand you're at a disadvantage not having an attorney representing you, but on the other hand, I can't give a special exception to you. That would not be fair to the other parties who are also under that same requirement. So that's where I am. So I think you'll have to do the best you can. You can certainly, they don't have to help you, but if any of the other attorneys who are involved in this proceeding want to give you advice on that, you can certainly call them and talk to them about that. And they may be able to give you some insights, but that's the best I can say in response to your question. So, Ms. Fry, your hand is up.
I just would like to point out that while independents like Mr. Lowe and myself are having to hold up to that December 17th deadline and learning how to write this testimony, but BlueTriton gets to the 30th because they can see everything else. And I do want to just put on record that, we're at a double disadvantage at that point, it seems. So, but I understand, and I'm happy to submit rebuttal evidence, but thank you.
Okay, thank you, Ms. Fry. And to just clarify, I don't want to go around this too many times, but what BlueTriton gets to do on December 30th is not a second round that some other parties don't get. They can't say, hey, I thought of these 5 additional witnesses that I hadn't thought of before, and I'm going to designate them now. It's a very, very narrow exception if the prosecution team brings new charges against them that they did not know about and could not anticipate, then they can respond to that. And the reason they're in a different situation from anyone else is no other party has charges being brought against them. So again, that's why I'm where I am on that. Do you have something else to say, or can we move on? Okay, you can take your hand. Mr. Lowe, did you have something else, or your hand is now down too? Okay, Mr. Petrozelli, your hand is still up though. Go ahead. I think we're just about done with this issue, but if you have something else, go ahead. But go off mute before you talk. There you go.
Mr. Lilly, can you perhaps clarify what you mean by new charges? Do you mean do you mean something outside of 1112A? Do you mean something, completely remote from anything that's in the CDO? Or do you mean something that could even be tangential or foundational to something in the CDO?
A little hard for me to answer that question since I don't know what you're going to do. I'll do the best I can. I'll just say, if the prosecution team submits written proposed testimony or exhibits that contain substantial evidence or arguments that are beyond what's in the draft cease and desist order, the report of investigation, which is incorporated into the draft CDO, or any of the documents that the prosecution team has already produced to BlueTriton, and BlueTriton can show that, and BlueTriton wants to respond to that, then they may. But it basically has to be substantial new information or substantial new arguments. I think that's the best I can do, not knowing what you might do or what BlueTriton might argue. So I'll leave it at that unless you have some further question.
I'll leave it at that.
Okay, and if we have to, we're flexible. That's why we have hearings. We have to go through these processes one step at a time. And I realize everyone's not completely happy with how we're going forward, but for a variety of issues, but we're doing the best we can to have a fair hearing going forward, to get the evidence in so we can evaluate it and prepare a proposed order. So with that, issue number 3, are there any other procedural issues concerning the hearing that any of the participants would like to raise? If so, what are these issues? And Mr. Petrozelli for the prosecution team did submit a comment on this in the prosecution team's second amended pre-hearing conference statement, which states, which asks that the last sentence of the first hearing issue be changed. It currently reads, "This issue does not include issues specifically associated with the judgments in the 2 listed cases involving the Santa Ana River system from the 1960s, to this issue does not include whether BlueTriton is violating these judgments." So, Mr. Petrozelli, do you have anything you'd like to add to that?
Yeah, and again, I think I'm trying to avoid, potential unintended consequences, just because we believe that what you're trying to avoid is specifically adjudicating violations of the judgment itself. To that end, we could perhaps further clarify that request and add at the end of our suggested modification as a matter of law. Because as we've talked about, it's sometimes hard to predict where things go and how something might be relevant. And I think it would be difficult to fully preclude any discussion, citation, or use reference to those judgments when we don't know how they'll come up or how they could come up or how they could be relevant.
Okay.
And just like anything else, you make an offer of proof.
All right. And I mean, it's clear that where this is coming from. I added this sentence to hearing issue 1, following up on the hearing officer's ruling that I issued, which basically was denying San Bernardino Valley Municipal Water District's request to expand the hearing to include issues specifically related to those judgments. So I think your concern is valid. I think your proposed amendment makes sense. Mr. Donlin, I'll start with you. Do you have any comments on that? I mean, I think we all sort of know what we're trying to get at here, but I appreciate Mr. Petrozelli's concerns. I mean, we're talking about violations of law related to the diversions of these facilities, and not the bigger question of how those diversions might fit into the Santa Ana River system and water right accounting. But Mr. Donlin, do you have any comments on this?
No, Mr. Lilly, I think this issue was addressed in your first discussion topic regarding the scope of the record. If there's information in records and documentation in the prosecution's case in chief that speak to these judgments, then of course it's in the record. If Mr. Petrozelli is suggesting that maybe there's a new line of argument, this is the issue that we were concerned about with respect to issue 1. And we would like to better understand and have an opportunity to respond to that. I don't have any material objection to what Mr. Petrozelli has suggested. The raising of this issue is more of a concern than the specific language that he has proposed.
Okay, I don't think this is going to be a problem. I think there's going to be a fairly bright line between basically what's going on in the vicinity of the springs and what's going on in the overall Santa Ana River system, but I may be wrong. I don't know how the evidence will come in. So Ms. Nickel, your hand is up. I'm sorry if I raised the your client's motion, but that was what, or request for expanding the hearing issues, but that was what prompted this. So would you like to comment on this?
Well, actually, I think Mr. Donlin resolved my concern by agreeing that Mr. Petrozelli's revision is appropriate. I think Mr. Petrozelli did a nice job of threading the needle on the issue with, understanding your ruling and staying within it. I think that Mr. Petrozelli's revision is a good one.
Okay. And just so we're clear, I'll state the obvious. If someone thinks that the judgments are being violated, they can go to the court or the courts that issue those judgments and ask for the court to impose relief for those violations. You're all lawyers, you all knew that, but I'll just say it even though it's obvious. So Ms. Doty, your hand is up. Please go ahead.
It's on a different topic because you had earlier asked generally. So do you want to move on, or are we?
Let me just wrap up this. Does anyone else have any comments on this issue? I think we've reached some sort of a rough consensus on this. So if there are no other comments on that, Ms. Doty, please go ahead with your other issue.
I had a question because we're trying to limit the time for testimony of each witness about authenticating documents. And I understand we don't have to adhere strictly to the rules of evidence, but that we want to hew close to them was my understanding from the prior conference. So do you anticipate that we will try to do that in advance to the extent possible? We find it usually works pretty well if to just do that during the hearing. And I will say, and this might help you and everyone else, the best way to authenticate exhibits is for your witnesses' written proposed testimony to describe the exhibits. For example, exhibit, whatever the party's name is, 5 is an accurate statement of my professional experience and qualifications. If that's in your written testimony, then when the witness basically confirms his or her written testimony, that has authenticated that exhibit. Same for something else. Exhibit 7 is the data that I've collected regarding this or this and this. So if people can have their written proposed testimony describe and authenticate all their exhibits, then we don't need to spend any additional time during the hearing separately authenticating those exhibits. So is that reasonably clear? Frankly, that's how you would do it in court, is you would have the witness testify and authenticate each exhibit. So we're just having the witnesses do that with their written proposed testimony instead. And then I have a follow-up question if there's nothing else on that.
No, go ahead, please.
Okay, another question had to do with the documents that need to be submitted in paper format. We had discussed that at the last hearing as well. And you had said that if the documents exceed 100 pages, that you didn't require a hard copy. But then a number of us, I think, will have a lot of documents, which in the aggregate will be 100 or more pages, but individually, those documents are going to be fewer pages. Do you want every exhibit to be produced in paper copy in that case, even if it's quite a few pages, hundreds to thousands?
I do want paper copies of each exhibit that's less than 100 pages, yes. And that's just to the Administrative Hearings Office. Everything else you can do electronically, but I do want those. Otherwise we have to print them all. And frankly, that's just our normal practice, is to put that burden on the parties. As long as you mail them by the filing deadline, if we get them a few days later, that's okay. But if you have 50 exhibits and each one is 25 pages long, yes, I do want paper copies of all those exhibits.
Would
But
you
if any
mind,
exhibit's over 100 pages, you do not need to submit a paper copy of that.
would it be permissible for us to mail them within, say, 3 business days, since we're submitting an electronic copy as well? Just because printing sometimes takes a while, especially in binding, and could we have 3 business days to get the paper copy in the mail, please?
I think that's reasonable. As long as you upload the electronic copies by the deadline. That's
Understand.
reader. But I will put that in the order if that helps. That's fair. I realize since many of us are not working in offices, it's a lot harder than, I'll just say, back in the old days. And that doesn't prejudice any other party. This is mainly a convenience to my office, but I can assure you, I do make files of all of these paper exhibits, and I read them and I mark them up and all that. So that's why I'm requiring this. All right, Mr. Petrozelli, go ahead.
Oh, I was going to say that for the board in general, it's actually not standard practice, at least not anymore. In the last 2 to 3 years, board hearings in general, they actually stop requiring paper submissions, and especially with Cal Water Fix. So
well,
it's my experience.
It's the practice of my office, Mr. Petrozelli, so that's what we're doing in this hearing. So I'll just leave it at that. All right.
Mr. Lilly, if you don't.
Go ahead, Mr.
mind.
Sanders. Yes, please.
Can I ask a question about potential impeachment evidence if it was not part of our case in chief, but we're introducing evidence to impeach a witness? Obviously, it wouldn't be disclosed in advance. How do we authenticate that evidence?
Okay, thank you. That's a good question, and I don't think that's addressed in our hearing notice, and that does come up sometimes. So, and just for those of you, particularly if you're not a lawyer and are wondering what the hell is going on here, impeachment evidence is on cross-examination. Say the prosecution team has a witness and Mr. Sanders wants to ask that witness about a letter that witness wrote 3 years ago about this matter, and that letter is not in evidence, but wants to have the letter in evidence so that he can ask that witness questions about that. That's impeachment. And frankly, it really helps our process to have the actual document in the record at that point. So what we'll do, Mr. Sanders, is if somebody has evidence, and usually there aren't a lot of exhibits like this, but if there are some, during the hearing, we'll ask whatever the easiest way to transmit that, probably to just email it to our office, and we can take a break from the hearing to do that. If you have several, maybe do them all at once. And then we can label those with exhibit numbers and post them to the AHO-FTP folder so everyone can access them. And then we will put them up. Our staff is very capable, and they can put them up on the screen while the attorney is asking the witness questions about them. So we do have a way to deal with that. That's how we'll do that if necessary. Does that answer your question? Thank you. It's a good question. Thank you. All right, Mr. Petrozelli, go ahead.
I think that kind of evidence is usually handled through rebuttal, and the procedures and the regulations do prohibit the submission of surprise evidence.
There can be rebuttal, but not always for this. I mean, this is a perfectly appropriate way to do cross-examination. And I'll just say it really helps everybody to have the exhibit in front of the witness. I mean, the example I gave, let's suppose Mr. Sanders is cross-examining a witness about a letter the witness wrote or about data the witness compiled. It's going to be a lot easier for the witness, for all the attorneys, and for me to have that document up on the screen during that cross-examination. Now, it may be some of this can come in as rebuttal instead or in addition, but impeachment is an appropriate way to proceed on cross-examination. And sometimes lawyers want to use exhibits to do their impeachment. So I don't want to foreclose that. And frankly, again, as I've said before, my goal is to have a clear hearing record. And if an attorney's asking a witness questions about a document, I want to have the document up on the screen. That helps me and everyone else, making sure we are literally all on the same page. So that's my feeling about that. Impeachment may be different from rebuttal. Okay. The next thing on my list regarding hearing procedures is BlueTriton's second pre-hearing conference statement states that BlueTriton would like to discuss the following statement in the December 17 hearing notice, which the hearing notice states, the hearing officer and other AHO staff members may consult with staff of the Division of Water Rights, attorneys in the board's Office of Chief Counsel, members of the executive management of the State Water Board, and State Water Board members to discuss or deliberate on matters relevant to this proceeding. And just to clarify, I think it may be somewhere else in the notice, but we do not consult with staff of the Division of Water Rights who are on the within the enforcement section, because obviously they're part of the prosecution team, and that would be improper ex parte. But there are other staff within the Division of Water Rights who they have a hearings unit and various other staff, other units that are not involved in enforcement. And sometimes we need to consult with them. They may have technical expertise that's relevant to us. We certainly consult with attorneys in the board's Office of Chief Counsel. Back in the old days, sometimes there were attorneys in the Office of Chief Counsel who brought prosecutions, but I don't think they do that anymore now that the board has a separate Office of Enforcement, of which Mr. Petrozelli and Mr. Prager are members, and we certainly would not consult with them. And the board's executive management, we sometimes consult with, and certainly the board members. If we consult with more than 2 board members at any one time, we notice, as required by Bagley-Keene Act, we notice a closed session to do that. But that's our normal process. So I guess I'm not sure, Mr. Donovan, what your questions are about that. Maybe I've clarified it, but do you have any follow-up questions?
Yes, I do, Mr. Lilly, and thank you for addressing this issue. I understand that is the practice in some proceedings that the hearing office has employed relative to obtaining information. But in this proceeding, it is our expectation that all of the evidence, information, argument, analysis that will inform ultimately your proposed decision in this matter will be in the record. And we just wanted more insights from you as to what the nature of those communications might be in this particular case. Do we have an opportunity to examine folks from the Division of Water Rights that you may consult with, et cetera? So that was specifically what we were getting at.
Okay. Well, and that's a good question. And the answer is that any evidence that is relied on in the proposed decision, in the findings or anything like that, must be in the record. We can't, basically say, hey, we have the proposed decision can't say, well, I talked to this geologist in the Division of Water Rights off the record, and he or she said this, and therefore we're basing our decision on that. That would not be appropriate, and we would never do that. But we, under the deliberative process and covered by the deliberative process privilege, we may very well ask a technical person in the Division of Water Rights who's not involved in the enforcement section. The Party A has submitted this technical evidence, Party B has submitted this technical evidence. Could you look at that and tell us what your thoughts are on, basically who we should follow or who we shouldn't, or what the defects are in certain testimony? And similarly, and what happens a lot more often, is we may very well talk to somebody in the Office of Chief Counsel and say, Party A has made this legal argument, Party B has responded with this legal argument. Do you have any insights on this? Do you have any statutes or court decisions that may be applicable here that we should be considering? And of course, if we consider those court decisions and decide they're relevant, we cite them in the proposed order, and so forth. So that's how the deliberative process works, and works in other matters and will work here. But absolutely, any evidence that is relied upon has to be in the administrative record and will be. So I hope that clarifies your question.
Well, with all due respect, Mr. Lilly, it doesn't. The concern is the second example that you used.
This is one of my pet peeves. You're going to argue with me. You disagree, and go ahead. But please tell me why you disagree.
Okay.
But you don't respect me, but go ahead.
I do respect you very much, and I respect your legal mind. And the key issue here in this case, we believe, is the legal standard. And if there is consultation between the hearing officer who is adjudicating the legal issue in this case with the Division of Water Rights staff, of which Mr. Petrozelli and Mr. Prager are members, that is not before the parties, we don't have the opportunity to cross-examine those legal analyses and those opinions that you might be getting. It does raise a concern that there is information, if not evidence, that you are obtaining to inform your decision that is not being put on by the prosecution and not made available to BlueTriton.
Okay, and just to clarify, this is a pet peeve of mine with the Water Board. They used to have their organization charts posted on their webpage, but they had to take them down because of accessibility requirements. So now parties no longer, interested people can no longer access them. So it's a little hard to figure out how the board's organization is set up. But Mr. Prager and Mr. Petrozelli are not in the Division of Water Rights. They are in a whole separate unit called Office of Enforcement, headed by an attorney, Yvonne West, who reports directly to the board or to the executive director and then the board. But they are not in Office of Chief Counsel. They are not in the Division of Water Rights. And we absolutely will not talk with anyone in the Office of Enforcement about this matter at any time aside from these public proceedings. So I hope that allays some concerns of yours. Now, there may be other attorneys, Michael Lawfer, Chief Counsel, or some of the people who work in his office who are not involved in any way with the enforcement section. Mr. Lawfer is the attorney to the board, he's Chief Counsel to the board, and we may very well consult with him on legal issues. And that may affect, I'm going to be candid about this, that may affect the analysis that's in the proposed order. But I think that's perfectly appropriate under deliberative process. You will see, all the parties will see in the proposed order what the ultimate legal analysis is that my office has prepared and that we're submitting to the board. And of course, then you can comment on that during the board meeting. So that's the way it's done. I think we are pretty scrupulous to set up ethical walls so that we avoid any issues of ex parte communications, and yet so we still can function within an administrative agency. So I'll try again. Does that help at all? Or tell me if you still have concerns, and please go ahead. If you have concerns, let me know what they are. This is very important, and I'm very sensitive to this issue. So I'm glad we're having this discussion now.
It doesn't address our concerns, Mr. Lilly, and I thank you for the added detail. While I do understand that the State Water Board, as an administrative agency, a large agency, exercises deliberative process, our expectation was that this proceeding would be before an independent hearing officer that would adjudicate the matter before it based on the evidence and argument made by the parties. And I don't need to elaborate any further. I think I've made my point, as have you, and I will let it rest there. Thank you.
Okay, well, thank you. And certainly, this isn't just for you. This applies to any other party as well. But if questions regarding this come up, please feel free to raise them at any time. But that is one of the reasons we put it in the hearing notice, so that we were being honest about what we plan to do. But as you know, Mr. Donlin, administrative law is sort of a strange animal. I know from law school, I learned a lot about how it is and is not like court proceedings. But the bottom line is that here we have a board whose 5 members make the final decision, and they have an attorney, Mr. Lawfer, who advises them. And we do have to have some interaction with Mr. Lawfer for that process to work. I am not an attorney to the board. They're not my client. That's, as you said, our office is an independent office, but they do have an attorney and an attorney's office who represents and advises them. So that's the way we go forward. But anyway, if you have future concerns on this, please feel free to raise them. But I hope that explanation at least tells you how we plan to proceed.
Thank you, Mr. Lilly.
And with that, does anyone else, this is a very important issue, and I didn't mean to belittle the with all due respect thing, but anyway, I appreciate your comments. And does anybody else have anything they would like to add on this? Okay, another matter, very important, site visit. Let me just tell you about this. We did get comments from the parties, particularly the prosecution team's pre-hearing conference statement on the site visit. The prosecution team lists 6 different types of points of interest that it recommends being included in the site visit. And the prosecution team's statement also raises several important questions about the logistics of the site visit. And I will get to those questions. But first, I do want to note that I believe a site visit for a hearing like this one is very important, both for me and my colleagues and for the other parties who may or may not be as familiar with the site. I mean, I've been involved in water rights matters in California for many years, many decades. And just uniformly, almost every matter, I look at the topo maps, I look at the photos, I look at all the statements. I think I have a really good idea of the lay of the land. And then when I go out there, I always realize there's just something in real life in 3 dimensions that I've missed that's important, and that I need to see, or that helps for me to understand the situation that I need to see. So that is why I'm going to the trouble of the site visit, even though there are some logistical challenges. It's just really, really valuable for me and my colleagues. And as I say, I think for the other parties as well. Now, this one, there are some important issues regarding the proposed itinerary. And I know essentially nothing about the site. I have read the report of investigation and the draft CDO. That's about all I've read that is relevant to this matter so far. I'm looking forward to all your exhibits. But so I'm not in a very good position to set up the proposed itinerary, but you all are. So my plan is to direct the parties, and again, I'm going to have the lead be on the prosecution team and BlueTriton, but to include all other parties who are interested to confer. You don't have to meet in person, but set up a conference call and develop a proposed itinerary. And in particular, from my reading of the papers that I've seen in this matter, I know that both Ms. Fry and Mr. Lowe have decades of experience in the area and detailed knowledge of the topography. So I hope that they can and will participate in this process to develop the itinerary, and you all can take advantage of their knowledge. And of course, I know that BlueTriton and its staff knows the area as well. So if possible, the itinerary should include visits to all the points of interest listed in the prosecution team's second pre-hearing conference statement. We've set up 2 days. We can have 2 full days. We can have more if we need to. I'm hoping we can cover it in 2 days. My understanding, I think from Mr. Lowe's statement, but I may be wrong, is that many of these sites are accessible on walking trails. And to the extent possible, I would like the itinerary to plan to access as many sites as possible by walking. It's okay with me, even if we have to walk for several miles. I think you're all younger than I am, and I can still walk several miles. I hope all of you can. And that way, we can get there. Obviously, with helicopters, there are going to be issues with how many people can go. So walking is good. I don't particularly want to go cross country and start clambering around. Not only we might have some unexpected encounters with rattlesnakes, but I think that's going beyond what's appropriate for a site visit like this. But I'm hoping that we can do a fair amount of access by walking. I know Ms. McGuire mentioned potential use of helicopters. And if we need to, we'll talk about that. As I say, I'd prefer not to if we don't have to, but if there's some sites that there's no other way to get there, then we can do that. In that case, if numbers of people are limited, we have to have at least one representative from the prosecution team and one representative from BlueTriton and one of my staff members and me, 4 people minimum. If we can have more, that's fine. We can certainly record that too. And I think with that, the 2 adverse parties, we at least have a way to deal with the ex parte issue. But I'll be interested to hear your comments about that. And so and we can do that if we have to. Regarding the process during the site visits, one of my colleagues will have a GoPro camera and we'll use it to record the video and audio conversation at each stop. And we will add those recordings to our administrative record. At each stop, I will ask the person who is leading the tour and frankly, other knowledgeable people to explain the physical features at the stop. And again, not getting into the details, but just explaining what we're seeing and what is what. And we'll probably take a few pictures. We try not to take too many because we don't want the record too burdened, but we do take some pictures that we add to the record. Other parties may ask clarifying questions like, what is this pipe? Where does the water in this pipe flow? Or things like that. But if people have more detailed cross-examination questions, like, I'm not sure what the line is, but how long is what's the flow rate through this pipe, or how long has this pipe been in existence, or things that really get into more detail, we can do those during the rebuttal hearing phase. And the reason I do that is it's difficult to have a good record and fairness to all parties while we're out in the field. And we can all gather around and hear somebody talk and we can try to record that, but it's not as good as this proceeding for getting a good record. So any kind of detailed cross-examination I'd like to do after we get back onto Zoom. Anyone may bring a court reporter to the site visit, although frankly, it's pretty difficult for a court reporter to set up and record at each stop. I have been on views in court cases where they've done that, but it's a challenge, particularly if we're hiking several miles. So it may be better if anyone wants a court reporter's transcript of the site visit to ask the court reporter to prepare a transcript from our video plus audio recording. We certainly are not going to bring a court reporter to the site visit. So with that, that's me rambling a little bit, but I did want to tell you my thoughts on this. This is very important, and we have some logistics. So I'm going to ask parties for comments, and I'm going to start with Ms. McGuire, because I know last time you had some important comments about the site visit. So please go ahead, Ms. McGuire. I see your hand is up.
Thank you, Mr. Lilly. I would basically explain to the group here today that we would propose that the process follow the same itinerary that we used when we brought the prosecution team technical staff onto site in 2016. We put an itinerary together. The site tour itself lasted 1 day. It facilitated stops at each one of the spring sites that were listed in Mr. Petrozelli's response. I don't know whether it included the U.S. Forest Service spring site, but it does include all of BTB's sites. There are a few logistical challenges that we would have to address. Although it may be possible to reach the higher sources of water in the canyon on foot, it's not possible for all of the sites. It is necessary to take a helicopter and land and then walk to some of the spring sites. In addition, the space around these spring sites is limited. It's fairly narrow. So you have the physical constraint of the helicopter itself can carry 5 passengers in addition to the pilot. He, of course, could make multiple trips, and we'd be prepared to facilitate that. But when you get to a spring site, typically it can't accommodate more than 5 to 8 persons at a time. So that makes it a little bit more challenging. I also believe that we would probably have to clear some of the trails if the size of the party gets large enough and allow passage of those individuals. So it really would be important to identify who's going to attend and to some extent make sure that only critical parties attend, because it will present some challenges to ensure that everyone has full access and full ability to view the sites once we get there.
Okay, thank you. And I appreciate your consideration and your comments. One question that we have administrative services people who have various rules for State Water Board doing field visits, as you might expect. One question is, will BlueTriton charge the State Water Board for the helicopter time?
BlueTriton's prepared to pay for the helicopter cost. It is relatively expensive. So I believe it runs in the neighborhood of over $3,500 a day. So ideally, if we did it in one day, that would allow obviously a little less expense. The helicopter is going to have to be stationary on site, obviously, to allow access should someone get hurt. Snake bites come to mind as well. So they would be sitting on standby for us throughout that time. And so that's the reason for the expense of that helicopter. I don't know whether the fuel itself is extra, so there may be some costs there, but BlueTriton is prepared to absorb that. However, each of the parties would be responsible for getting to Ontario Airport. That's where we would depart from. We would provide vehicle transportation to the site and then to the helicopter to allow the transportation up into the canyon itself.
Okay, thank you for that clarification. All right, I'm going to go down the list here. Mr. Petrozelli, do you have any comments? And I don't know if, were you there during the 2016 prosecution team visit? So you know what Ms. McGuire is talking about?
No, I was not. And I have to apologize because, Mr. Lilly, there's been a lot to, you said a lot, and there was a lot to follow. So please forgive me.
Okay. Sorry if I went too fast.
Clarification.
Go ahead.
You talked about, I think, a four person minimum. This is supposed to be, this is supposed to be a public hearing. I think it would be, incumbent, and it creates perhaps some due process and public hearing questions if, not every party is permitted to have a representative. As for us, I was not there at the initial inspection. That's why, in terms of a minimum number of people, I would ask for at least myself as well as our technical staff. Victor, who was there and did see it, as well as our other witness, Tomas, and their supervisors, Julie and Robert. I would also ask that BlueTriton be the one to prepare the trip plan, since they have the helicopters. We'll need to, and we would also ask that the Administrative Hearing Office submit and develop that trip plan and submit it to the DAS, for approval.
And just for those of you who don't know jargon, DAS is the Division of Administrative Services within the State Water Board.
Yeah.
Okay, thank you.
And perhaps too, Mr. Lilly, if there's something you want to see, especially if there's something, the site plan is, or the site visit is planned for after the case in chief. So you'll learn more about what is happening by the time we do the site visit. So if there's something, that that your office wants to see, please tell us what it is, so we can incorporate it into the itinerary and trip plan.
Okay. And I don't know right now, but certainly after the case in chief, I may know a lot more, but we need to get started on this, but we may have to make some refinements as we go on. So thank you. All right. So I see Mr. Lowe, your hand is up, and I'm glad you were here to comment because I know you have extensive experience in the area. So what are your comments on this?
Yes, I had some medical issues, so I haven't been able to go in to the actual spring locations, except for the spring number 7 complex. Recently, I have a blood clot from whatever, COVID or whatever, but it's very important to understand the whole situation, that we include some visits to the downstream sections that are affected by the removal of the 70, 80 million gallons of water each year. It's not just at the spring sites we need to look at, but there's several locations downstream that we can drive into and stop and have good conversations about the endangered species that exist downstream, the habitat that they're in, how that habitat is affected by water withdrawal. So I would suggest that we go in on the Forest Service road that accesses the lower part of the stream, at least for part of a day, and see the full ramifications of the water removal in the headwaters.
All right, thank you. And I certainly hope you have recovery from your medical issues. That sounds serious. So Ms. Fry, your hand is up, and I know you also have experience in the area, so please let us hear your comments.
Okay, so I was just in at the Upper Spring sites on Saturday. Okay. And I think that all parties need to be involved. I feel more comfortable instead of working with BlueTriton directly, because I would like to be involved in planning the site visit as well. Maybe we can work with the prosecution team. Okay. And because I do think there's a lot to see, like Mr. Lowe said. I will tell you what we did. We hike in. That's not really a problem from the top to see the headwater spring. Site 1, 2, 3. We went down to 4. I don't know what agility everybody has. Obviously, I'm no spring chick, but I can do okay. And then you can probably do 7. I would think it's going to take several days. Also, it would be good to have granted access to the private area below, because much of BlueTriton's operation runs across Arrowhead Springs property. As private citizens, even though we've asked, we've never been allowed. Actually, I've been threatened even to go in there. So that would be helpful in accessing some of the lower areas, because I know in the past when I've hiked into the lower areas, it was 5 miles to get to Strawberry Creek and then a mile up the ravine, which was a beautiful hike, but that took a whole day, to be honest. The other thing I think you're going to have to be concerned about is a little weather, because this is up in the mountains. So if we have a snowstorm, roads will be difficult. I know the reporters that have gone up with Nestle's on their tours got into some bad weather at one point and got pretty scared a few years ago. So I do think there has to be some contingency plans. I do know I've been up to that site, hiked it many times, and I pretty much know the area, and I think it'd be essential maybe to have somebody like me involved in the planning as well.
Well, thank you.
Because we want you to see everything. I think it's important. It really gives an understanding of what's going on.
And just one thing to comment on about weather. I totally agree. We're going to have a contingency plan. I mean, it's great. I love tromping around in the snow, but we're not going to do that on this site visit. And we're certainly not going in any helicopters if the weather is bad. I won't say anything more. That's just not acceptable. And nobody wants to do that. If the pilot has any hesitation at all, we're not going. let's just be real clear on that. That nothing we do is worth risking health and safety on. But as far as the logistics, we will work to develop a plan. I'm hearing a lot of different factors, but I think we can work through this. So we have a lot of other hands up. So Ms. Doty, why don't you go ahead next?
Hi, I agree with the comment about needing access to some of the private lands at the bottom to be able to see what's happening there. And then another issue is that this isn't actually on land owned by BlueTriton. Of course, this is on federal Forest Service land. And so we are going to need to coordinate with the Forest Service for whatever happens here. And it's my understanding that BlueTriton doesn't yet have a permit from the Forest Service for its operation there, that is still Nestle. We've been FOIAing that information and haven't gotten an application or a new permit. So our understanding is that this will need to go probably through the Forest Service to ensure that we're authorized, especially if we're taking helicopters, to be landing on federal land.
Okay, I'm going to ask Ms. McGuire to respond to that, but Ms. Miller, your hand is up. Why don't you go ahead next? Thank you.
Sure, just for everyone's benefit as we try to plan this out. CDFW would be interested in bringing 2 people. It would be myself and a senior environmental scientist who's familiar with the area out of our Region 6 office. So I don't know if we'll be limiting. I'm assuming there's some space constraints, the number of people, but just wanted to put that up for consideration.
Okay. All right, more hands are up. And one other thing I want to clarify, which maybe will help limit and focus this a little bit. My hearing officer's ruling did state that this hearing is not going to consider the public trust issues because they were not in the draft CDO or report of investigation. And I know some parties had asked about that. However, just for the purposes of context, I certainly would like to see Strawberry Creek downstream of the springs. I mean, that's just necessary for a complete understanding of the physical surrounding and basically just hydrology. So I just want to make it clear, even though I want to see that, that doesn't mean that I'm going to change the hearing officer's ruling on consideration of public trust issues. So I hope that is clear. So let me go around. First of all, we have not heard yet from Ms. Nickel. So Ms. Nickel, go ahead. Please tell us your comments or concerns.
Thank you, Mr. Lilly. I thought I would just follow on and just put a placeholder that for San Bernardino Valley Municipal Water District, we would like to have 1 or 2 folks participate, one being a senior engineer at the district and possibly myself or another attorney for the district.
Okay, thank you. You can see the challenge I'm laboring under here, but let me go ahead. Hands are still up. Let's see, we're going back for a second round of comments. So for Ms. McGuire, why don't you go ahead and you've heard a lot. Why don't you go ahead and respond now or go ahead and give us your additional comments.
Thank you, Mr. Lilly. A couple of thoughts here. One is that BlueTriton has arranged these types of helicopter visits in the past in order to tour the sites. I think it's extremely appropriate that BlueTriton take the lead on this because we know the canyon, we know our facilities. And of course, the issue ultimately is focused on the collection sites. In addition, we use the helicopter to access the canyon for 2 reasons. One, and most importantly, is safety. Hiking in that canyon, there are steep elevations and terrain to cover that creates a risk for the parties that are hiking in the canyon, and of course creates liability issues that I think we have to address. And then secondarily, timing. The helicopter permits faster access to these sites. If we are talking of a couple of days, that becomes more difficult to schedule. Weather becomes a larger issue. So frankly, the site visit that we performed for the prosecution's technical staff took about 7 hours, and that was to cover all of the sites. We start adding things on, of course, the time extends accordingly.
Okay, and we certainly don't want to do anything in the dark, at least not up in the air
I think that
or
would
in the field. I think the good news is if we do this in January, hopefully the snakes will be dormant, although I guess in Southern California, we can't be sure of that. All right, so let's go back on. Ms. Doty, please give us your comments now.
Right, I neglected to say when it was my turn before that we do plan to have, we would like to have 1 or 2 people on the site visit. So a representative of our client and our hydrogeologist. And then as far as the downstream access goes, we think, I think this is what you were getting at, that it's important to understand what the stream channel looks like downstream in several locations. So that I would agree is not a public trust issue. That's an issue of where were the water not diverted, it would flow.
Okay, thank you. Ms. Fry, go ahead.
Okay. The truth is that it's this site is on the upper springs is very close to Highway 18, the River World Highway. So there's a pull-out area, action pass, it's a public forest. We're allowed to go on our public lands, and I have an action pass. So it's no big deal. We've taken big groups of people. It doesn't take very long to hike from the top to the spring sites. It's going to take you longer to hike between the spring sites, even with a helicopter. So some area is rugged. You definitely need good hiking boots, and a walking stick can be helpful. It is about 5,600 feet, so it could be a little cooler depending on the weather. We'll just have to see. And then, I've hiked most of this area. There's a small portion I have not, but it does take a little time between the spring sites. So just be aware of that. I don't know that the coming down, it seems like parties could easily join us from parking at off the Highway 18 and hiking down, because it just doesn't take very long, because we don't have a helicopter. We're the public.
Okay, so is that to all of the spring sites or just to some of them?
That is I'll tell you which ones. The Headwater Spring, that's appropriated to the U.S. Forest Service, application 6108. Tunnel 2, Tunnel 3, 1-8 complex. 7's on the other side. That's not right there. So you're just going to have to go kind of back up to the top and go over to 7, but you can access that too. I haven't done it for a while, but that is accessed. The lower spring sites, 10, 11, 12, that's the one that it took me all day to hike into. It was a beautiful hike, and then up the ravine, which is quite a marvelous site. And I really saw a lot of Strawberry Creek, a lot of, it's interesting. Saw a lot of pipeline there. It would be easiest if we could access that from Arrowhead Springs, and because you would save a 5-mile hike in. So if we could get, BlueTriton has access and a relationship with Arrowhead Springs and agreements. So if we could all be able to gain that access, it might be helpful.
Are you saying, well, let me ask. If Arrowhead Springs granted access, first of all, what kind of a road is it to drive on to get as close as you can?
Well, I haven't come in on that side, so
okay, well,
I'm
I'll ask
not
Ms.
sure.
McGuire.
I had to hike in from the other side, and the bridge was gone. So
okay. I'll ask Ms. McGuire. We're narrowing in on this. This is helpful. Thank you. Ms. Palenke, your hand is up now.
Yes, I just wanted to also say that if for the Center for Biological Diversity, we would like to also have at least one attorney attend and one of our scientists.
Okay.
Thank you.
This is, I appreciate this. All right, Mr. Lowe, go ahead.
Yes, the Forest Service, the road that accesses the Lower Canyon is a Forest Service road, and it's used and maintained by Nestle or BlueTriton now to maintain their pipeline and facilities. So there is access on that road. It would be, you wouldn't want to take a low sedan in there, but a van that's used in the field would be fine. Pickup trucks. So there's there's vehicle access into the lower canyon through that Forest Service road that crosses the Arrowhead Springs property. And Fish and Wildlife and the Forest Service have always used that road for administrative purposes, and there is administrative access on that road. So like was said earlier, we'll want to ask the Forest Service to be a part of that trip, and which I'm sure they will want to. And then there should be no problem with access.
And how close does that get to, well, first of all, and this, I'm naive or uninformed here. Does that access the Lower Spring complex, or is it the creek below the Lower Springs?
No, it's actually the creek below the Lower Spring complex, but
Okay.
it's all affected by and flows are dependent largely on the headwater springs, where most of the flows come from, and it's where it's some of the most important habitat for the endangered species that are there, even though I know we're not supposed to talk about public trust.
Okay. Thank you. Ms. Fry, go ahead.
Yes,
go.
it's about, it took about, I'd say it's about a mile to hike from that point up to more, maybe a little more than a mile up to the Lower Springs. It's, and I'll be honest, I'm not sure on winter conditions. I hiked that in late October in about 2016. And I'm not sure how the water levels go. So we'll have to be really, cautious. I have been talking to the Forest Service rangers about a trip there. So maybe we can coordinate more. Anyway, so we were planning on something after the first of the year. So we have a lot of ongoing conversation.
Okay.
Too.
Well, of course, we all want, in the big picture, we all want rain, even if it makes access harder. The state needs
Right.
it. So, Ms. McGuire, go ahead. You've heard a lot.
Yes, you have.
I hope we're narrowing in. I'm not sure we are, but I hope we are.
Mr. Lilly, just to clarify, the Arrowhead Hotel property and the places that Mr. Lowe and Ms. Fry are speaking to are 2 miles below the lowest collection point for BlueTriton's facility. So it is a substantial distance. Secondarily, you would have to go through the San Manuel tribal property. They will not be probably open to crossing their reservation land. And I don't think BlueTriton should be put in the position of having to request that. In addition, this proceeding is to be focused on the collections of BlueTriton and whether or not that water is subject to the jurisdiction of the board and whether or not BlueTriton has the proper rights. I'm afraid we're going fairly far afield in terms of the scope of this site visit. And I think it's important to remain focused on the purpose of the site visit, which is really to educate you on those collection facilities.
Right, and that's why I did mention my comment about we're not considering public trust issues during this proceeding. However, hydrology in the vicinity can be relevant. So, and I realize that's probably a bit of a gray line between those two, but that's what I'm trying to draw. So, all right, one more round. I think we're just about done with questions here, although this has been helpful. So, Ms. Fry, please go ahead.
Please understand that BlueTriton collection facility crosses Arrowhead Springs property that is owned now by the San Manuel tribe. So it is important because it is part of this hearing. So I think you need to see and understand. And it's also, so I don't know that you can separate the two.
Okay. All right.
And it's not reservation land. This is private. It's a different thing. So they own, San Manuel has a reservation, but this is land that they have as in private trust. But BlueTriton does have an agreement with them on easements. And that's, so that's part of the case, actually.
Okay. Mr. Petrozelli, go ahead.
So, I mean, two things. even though public trust per se is not a part of this proceeding, there are things that, you know, BlueTriton is required to do under its, you know, Forest Service permit that may change its operations, that may change, you know, where it's taking water, where it's putting water back in the stream. So, you know, I would certainly consider that not necessarily a public trust issue,
Okay,
but rather an issue of how it's, you know, diverting and using that water.
okay. And it's very hard for me to make these distinctions more, not knowing any more details about the
Right.
facts.
Yeah, I'll also, you know, the board, if you do want to see the facilities that are on the Arrowhead Springs property, the board does have procedures for reaching out and coordinating with, you know, with tribes. So Cal EPA has a procedure, the water board has a procedure. I think Office of Public Participation is typically the entity that we would work through for that type of coordination. So if you want to see those facilities, you know, I think you can certainly ask. At worst case scenario, they say no.
And what facilities are those, Mr. Petrozelli?
Off the top of my head, I don't know. I'm only pointing out that if you want to see facilities that are on the Arrowhead Springs property, there are ways to reach out to the San Manuel Band, who is the current property owner, to facilitate access.
All right, Mr. Lowe, your hand is up. Go ahead. But you have to go off mute. You're still on mute. There
As
you
I
go.
said, the Forest Service and Fish and Wildlife have always had access on that lower road. The Forest Service has administrative access legally, and Fish and Wildlife has always had access to access that stream and work in that stream, which we've done for many, many years. So I don't see how San Manuel could suddenly deny access to the stream. And they do have relationship with BlueTriton. BlueTriton last year gave them 20 some acre feet of water that was National Forest water. So they have relationships. And to say now that they don't know if they could get permission, they don't want to be put in the position of trying to ask San Manuel, that's a bunch of bull. I'm sorry, but San Manuel will provide access if you guys request it and Fish and Wildlife requests it.
Okay, let's maintain polite conversation here, please. All right, Miss McGuire.
If I could just clarify, what is on the San Manuel property is the 4-inch pipeline, stainless steel pipeline, and the loading facilities for the spring water that is collected up in the canyon. It has nothing whatsoever to do with the draft CDO before this hearing office. And so for that reason, I really ask that we stay focused. This is expensive, this is time consuming, this is challenging. It is not intended to be a fishing expedition. It is designed to answer your questions about the applicability of the law to our collection facilities. And we really should stay focused on that. Thank you.
Okay, I think we're going to have to wrap this up pretty soon, but I'll go one time or more around. Ms. Fry, go ahead.
Please understand that Arrowhead Springs water, the original water rights, the water rights were on the Arrowhead Springs property itself. This is where this whole water rights issue starts. And it does really gain access if we can go across to Strawberry Creek. That 2-mile hike's not too bad up. It's but you need to see the creek. You'll be able to see the creek there going across that road. that Mr. Lowe talked about. I think it's important to understand the entire picture if we're able to do it.
All right, Mr. Lowe.
I'm sorry, I'm done. I just forgot to put my hand down.
Okay, that's all right. We've only been doing this for a year and a half now, but we're all still learning about Zoom, so no problem. All right, Mr. Doty, Ms. Doty, is your hand still up from last time, or do you have something more to say?
It is. It's just that if we were to examine only the collection sites, that's to concede the point of the characterization of this water. So the water should rightly be in the stream, downstream, and to get an accurate picture of that and to understand the hydrology and the hydrogeology, it's important to see downstream and to understand where the confluences of the various streams and where the water was originally drawn, which will be in the historic documents that are submitted. But to look in isolation only at the present day collection points would not give a full picture.
Okay, thank you all. This has been a very valuable discussion, if somewhat robust. And that's fine. That's why we have these proceedings. Here's what I'm going to do. I'm going to direct the parties to set up a conference call without my office involved to try to work out an appropriate itinerary. And I need to have somebody be in charge of that. And Mr. Petrozelli, I'm going to designate you to be in charge. It is the prosecution team who brought this matter, who started it all, as we used to say when our children were fighting. You started it. Sorry. But anyway, Mr. Petrozelli, please arrange a conference call and send it out to everyone, the notice to everyone on the service list to come up with a date. I mean, I realize we're coming up on the holidays, so try to do it as soon as you can because people's calendars are going to get to be fuller toward the end of the month. And let's try, you're all talented. You have technical people as necessary. I think getting a good map, topo map might be useful to mark out the sites and how we can get from one to another. I'm hearing, well, first of all, it sounds like, and again, I haven't pulled out the report of investigation. Maybe I should, but I'm hearing that there certainly are facilities, what I'll call the upper facilities. Let me just grab the report of investigation here. Excuse me. I don't know if somebody can help me. I think one of the attachments has a map here. Figures. Should have been a little more prepared on this, but let me just check here. Okay, Strawberry. Looking at figure 4 from the report of investigation, I don't know if this is the best one, but it's the one I have. The facilities shown here are, and I do see where the Rim of the World Highway goes. It looks like not too far as the crow flies above what's called Spring Tunnel 2 and Borehole 1, although it's obviously very steep terrain, and I don't know what the hiking is for that. I see Spring Tunnel 7 and the Spring 7 complex look to be somewhat farther from the highway and perhaps less accessible. Again, let's not go around again, but Ms. Fry, what is your view on whether or not we could walk to Spring Tunnel 7 and the Spring 7 complex?
You can walk to Spring 7. It's just that you're going the other direction. It's not that bad a hike. It's just like you could do one group like in the morning and then, refuel and go probably to that other 7. You'll need to start early, 8 or 9 in the morning.
But would you go from the highway down to that, or would you go from Borehole 1 over to that? This again,
you're going to go back to basically to the highway. There's a little pull out that we usually park at and hike down to 1, 2, 3, Headwater Spring 8, And then so 7's sort of like the opposite direction.
Okay.
You're going to be going east, you know, in the opposite direction, but it's doable.
Okay, and then I see that boreholes 11, 12, borehole 10 vault, and what's called spring at headwaters and confluence are quite a bit farther down. And I'll ask again, just short answers here, but I'll ask you, Ms. McGuire, is that something that could be driven to, or is that something that you're proposing helicoptering to?
I can't answer that, Mr. Lilly, at the moment, but I suspect I'll have an answer in just a second for you.
Okay, well, that's fine. It's really more important for when you all confer. So first of all, Mr. Petrozelli, does figure 4 show all the places that you're recommending we go to, or are there some places that are not on figure 4 that you recommend we go to?
So I don't have figure 4 in front of me, so it's hard for me to answer that question.
Okay.
If it's the one I'm thinking of, it doesn't show the location of the transfer station.
Okay.
And maybe I'm thinking of a different figure.
Okay, yeah. Go ahead.
But the transfer station is important, not just because of, it's obviously it's a key piece of their operation. It's also where they discharge flow that they take from the springs, but don't truck back into the stream.
And where is the transfer station in relation to boreholes 11 and 12 and vault 10?
I'm not the best person to answer that question.
Who knows? Mr. Lowe, where is that?
I'm mute.
There you go. Yeah, please go off mute and then try again. There you go.
The transfer station is at the bottom of the mountain, about 4.5 miles, I believe, stream distance from the springs at the top. So it's really the water's all in a pipeline by the time it gets there, but it is important, I think, to see.
Right. Okay. That's yeah. We don't need to. We've heard the arguments.
I had something to say though about your question about number 7, which other people didn't have an answer to. Number 7 complex is the easiest ones to hike to of any of them. There's an old graded road that goes down there, so that's the easiest one. The 1, 2, 3, 8, and Forest Service Spring, those will take it more time and they're more difficult than 7. So adding 7 on to that initial hike into those 1, 2, 3, 8, and 4 isn't a big deal. Like Amanda said, you could do the 1 through 8 early in the day, get that done by noon, go have lunch at the restaurant there, and then go back in the afternoon and do the 7 complex, and that would be an easy hike in the afternoon.
Okay. And then presumably the next day we could do the lower springs and the transfer station.
That sounds great. The lower springs is going to be, like Amanda said, a little bit of a hike, but if we get the access through the tribal Campus Crusade, now it's called Arrowhead Springs, if we get access through there on the Forest Service Road, it wouldn't be too bad of a hike, I don't think, up to 10, 11, and 12. Okay.
All right. So thank you. I sort of am getting an idea here, although not completely. All right, Mr. Petrozelli, go ahead. What else?
I was going to suggest that the AHO have a representative on the itinerary planning conference call. The AHO is going to be, if the AHO first, the AHO should be equally concerned with the health and safety of its people as everybody else. So it has, there is an interest there in input on the trip plan. And if AHO is also going to be developing the trip plan and submitting it to DAS for approval, then I think for AHO to really understand what kind of trip it's planning, it should really be on that call. So we don't provide something in writing and then your staff don't really understand what we're asking for.
Okay.
So,
all right, Ms. McGuire, your hand is up. Go ahead.
Yes, thank you, Mr. Lilly. I think the call is very important. I would recommend that one of our technical people who manages this facility be on that call because he can speak directly to the access. There's a lot of anecdotal information right now, but I think we need to be really clear on how long these hikes are, how steep they are, how accessible the facilities are. And just a point of clarification, BTB does not discharge any water at the transfer station.
Okay. All right. We're learning. We're covering stuff we're going to cover in more detail at the hearing, I think. Here's what I'm going to do. And this may be a little arbitrary, but I'm going to do this. Mr. Petrozelli, I'm going to direct you to set up a conference call, Zoom meeting, however you want to do it, with everyone except the AHO to go over this and work out what you can. And Ms. McGuire, please have your technical person involved in that. I fully agree with you on that. And I'll tell you, here are my concerns. If the hiking is a few miles here and there, and that means everyone can go and we don't need to go in helicopters, I would prefer that. I've been in helicopters before, but I don't particularly want to take those risks if I don't have to. And more important, or just as important, it sounds like we'd have at least 2 trips required for everywhere the helicopter goes. If they're, I think Ms. McGuire, you said there are 5 people per load, that's 10 people total, and we have at least that many people who want to go. I'm not sure that everyone has a right to go if we have to limit it for logistic purposes, but I certainly don't want to limit this if we don't have to, because this is an important proceeding and everyone wants to be able to participate. But having said that, if the sense is it just really wouldn't work to walk or drive and then walk because of logistics. And I'd say, if it's more than say 2 miles one way, then it's starting to get to be a problem. We can all walk more than 2 miles, but it starts to take more time and effort for us to do. So that's sort of a rough rule of thumb. But for each site, it's parking, walking a maximum of 2 miles in and 2 miles out. We have to do that at 3 different places. I think we can handle that over 2 days, of course. So that's my instinct, but I want you to all, number one, try to work on a logical itinerary. I'd probably like to start with the upper things. I like to go the way the water flows if we can. So it's sort of looking like the first day is either driving to the 2 spots on the rim of the World Highway where we can hike in, if that works, or potentially helicoptering in from Ontario if we have to. And then the second day would be going up from below. Hopefully we can get access over the road and the tribal road and drive. We'll try to rent a high clearance vehicle or van or something if we can, and others can do the same. And I would like to see certainly the lower diversion facilities, but I would also like to see the transfer facility. I understand your comments, Ms. McGuire. At the end of the day, it may not be relevant, but while we're out there, I'd like to see it in case I decide it is relevant. Just because I've seen it doesn't mean I necessarily use it as a basis for the order, but that's sort of the way I'm looking at it. So I would like you to do that, work out as much as you can, have somebody get a good map, preferably a topo map that shows the trails, or that you can put trails on, and develop a draft. And then I do agree with Mr. Petrozelli, we're going to need a second day where the AHO will be involved. I mean, I look at this as a discovery dispute for those attorneys who have practiced in court. Judges often tell the parties to try to meet and confer and work out what they can on discovery disputes. And frankly, usually parties can work out a fair amount. And then we'll come back to us for resolution and hopefully a final determination. So I'm looking at calendar-wise, today is December 8th. If possible, I see all your exhibits are due on the 17th. I'm just trying to decide when to set the next day of hearing, or whatever we call this, conference. I would normally set it for the 16th, but for my days of being an attorney representing parties, I know you're all going to be busy that day finishing up your exhibits. So I think I'll set it for the following week unless anybody has a problem with that. I'm going to look at December 20th. And well, darn it, I really don't. I know that's going to be where people are going to want to be starting to take time off. I'll tell you what, I'm just going to set it for the 16th, even though your exhibits are due on the 17th, just because I think that's a good time to do this. So I have another matter set for 9 to 10 o'clock in the morning on the 16th. I'm going to just check my office's calendar here. Bear with me and see if we can set it for the afternoon on the 16th, our second meeting, and then you'll set your first meeting before then. Okay, yeah, it looks like we're clean. Whoops, let me see if I can get you back now. Okay, so unless anyone has an objection, I'm going to set this conference call for 1 o'clock on Thursday, December 16. And I will leave it to you, Mr. Petrozelli, to set up what I'm going to call the meet and confer call before then. And the issues are to work out as much as you can. And, you know, you're all really constructive, knowledgeable people. So, and I realize you have some differences here, but I think if you all work together in a collaborative way, I mean, this is just to set up an itinerary. This isn't to decide the case. So please see what you can work out. And then let's do this. I want you to submit, Mr. Petrozelli, you're going to be in charge, a draft report, a proposal, and a report from the meet and confer and a draft proposal, which just really has to list the itinerary, amounts of time for the 2 days, and how we're going to travel. So I want you to submit that to me with copies to all the other parties by email by the end of the day on December 15. And then we'll plan to have our conference call, and we'll set up a Zoom meeting for our conference call at 1 o'clock on the 16th. So that will require you, I know it's short time, but I want to try to avoid encroaching into the holidays, and I'd like to get this resolved before our hearing starts on January 10th, particularly if we have to get approvals from within the water board. So sometime before the 15th, please meet and confer and work out what you can. So is that appropriate for this? Does anyone have any questions? All right, go ahead, Mr. Petrozelli.
Oh, two questions. What time was it on the 16th?
Yeah, 1 p.m. on December 16th. Okay. And we will send out the Zoom notice for that.
I also had a question from does BlueTriton have availability to, say, drones that could, facilitate access to or viewing of certain areas more easily or expeditiously than helicopters, driving, foot, things?
Okay, so Mr. Petrozelli, I don't want to talk about that today. We're taking a lot of time, but that's an appropriate thing for you to talk about in your meet and confer session.
Fair enough. And
I do want to say my immediate reaction is think about whether or not there's any way we can do that logistically so it can be added to the administrative record. I'm a little concerned about exactly what could be put in. I mean, maybe we could just have a drone video that's in the administrative record, potentially narrated by somebody, but think about that, because I do want to have a good record of whatever we look at, whether we're looking at it through drone or any other way. So anyway, go ahead. Did you have something else?
Oh, you mentioned the groundwater extraction reports, and we've talked about so much.
We're getting there. Believe it or not, we're not done with it.
Yeah.
We're not done with our agenda. This
Okay.
one was not surprisingly a long discussion. All right, we're done with site visit for today. The next thing on my list was the prosecution team's December 2nd motion to quash BlueTriton's November 30th subpoena, which has fairly detailed points and authorities. I need to have I want to set a briefing schedule for that. So it's going to have to be fairly short, because clearly we want to get this done as soon as we can and before the hearing. So, and Mr. Donlin, I did send out an email on December 3rd advising everybody that this was going to be under a short briefing schedule. But for opposition memos, which BlueTriton, of course, may file and anyone else may file, I'm proposing December 13. Do you have any objections to that? And I know you've already researched most of these issues. They were in your declaration and so forth. So even though that's really short, can you accept December 13th for opposition briefs?
Yes, Mr. Lilly.
Okay. And anybody else who wants to may file. Those are going to be due at 4 p.m., maximum of 10 pages, double spaced. And then reply briefs. Again, I'm sorry to push this because, but we have to keep this thing going. I don't want to lose our hearing date. So reply briefs will be due on December 20th at 4 p.m. They're not really necessary, but in case anyone wants to do a reply, they may, and 5 pages maximum for those. Okay. Now, groundwater extraction reports. Let's move, and of course I will try to issue a hearing officer's ruling as soon after that as I can. I'm the one who's going to be working over the holidays on that one, but that's okay. All right, Mr. Petrozelli, your hand is up before I go to groundwater extraction reports. Go ahead.
Okay, so I wanted to clarify, those are opposition briefs to the motion to quash, and then replies to those opposition briefs. Is
Correct.
that correct? Okay.
Yeah, thank you. And Ms. Doty? You want to go off mute? Your hand is up.
My hand is just up from earlier. I apologize.
Okay, we're all still learning the vicissitudes of Zoom, so thank you. All right, groundwater extraction reports. Here's the situation on this. My colleagues at the Administrative Hearings Office have obtained all of the groundwater extraction reports for the 13 report numbers that are listed in paragraph 2 on page 2 of the draft CDO that we could access through the Division of Water Rights Records Unit files. Those are the publicly accessible files. And we have posted those reports in a separate folder and various subfolders within the AHO FTP folder, which you all may access. The reports for many years, for many of the report numbers, are not in the records unit files, or at least they have not been able to find them. I would like to have all or as many as possible of those reports for as many years as possible in the administrative record. I do plan to formally introduce those into evidence during the hearing as AHO exhibits, just because I think it's important for us to have that background information. I don't know what, if anything, we will do with them for the proposed order, but I just want to make sure they're in the record. So does anybody, first of all, does anybody have any information regarding the reports that are not in the Water Right Records Unit files? And I'm going to start with you, Ms. Nickel, because I've learned from the Water Rights Record Unit that San Bernardino Valley Municipal Water District is the keeper of these reports. So do you have any information on that?
I do, yeah, thank you. As you mentioned, Valley District is the recording or the recipient of the groundwater records and has records of recordation notices filed for many, many years, I think as far back as the 50s. So those are, all public documents, and we're happy to provide those to your office and to the entire service list.
Okay, here's what I will do. I'm working with my staff. We will prepare a list of what we are missing. And of course, you can look on the AHOFTP folder and see what we have. And then I'll ask you we'll figure out the best way to do that. Those are probably too big to email, but we can probably just have you use your upload account that you're going to use to upload your exhibits. And then we can transfer them to the folder that will be available for everyone. So I will send you a request, of course, with copies to everyone else on the service list. And we'll go forward that way. I didn't realize this was going to cause so many questions, but I see 3 other hands are up. So Mr. Petrozelli, we'll start with you.
I saw that it looked like you had recordation reports back to 2010. My understanding is that the records unit has additional reports and or reporting years on microfilm or microfiche. So they do have other records.
And we have posted the records that they provided us for microfiche, some of which go back to 1954 or so. Those are in different folders, but within different subfolders within that same folder. They're also posted.
Yeah, it just looked like 2010. I was going to add that the initial reporting, the first year reports were required was 1957, but the filing of initial reports also required reporting for the 10 prior years. So you would, if you want, the full range of records, you would want to look for records back to 1947.
Okay, so I'm going to follow up on Ms. Nichols' offer to provide what she can. And of course, this will all be in communications that everybody will see. So then if anybody else has more information or more documents, more importantly, we can submit those too. And again, my goal is to just get as complete a database as we can for everyone to be able to use. So good, thank you. Ms. McGuire, any follow-up on this one? Oh, your hand is up.
It is, and I was simply going to add, we are prepared to supplement the record with any missing documents that you may have.
Okay. I appreciate that. We'll start with the San Bernardino Valley Municipal Water District, and we'll follow up with you if necessary. And these can be separate from your exhibit filings. We'll try to keep moving on this front as fast as we can. But thank you. All right, Ms. Fry, your hand is up.
There are historic documents prior to 1947 on the springs at the Water Resource Institute, and I provided some of them. They're in the Rowe report, and Susie Earp may have even more if she's the archivist there. So I have some of those records.
And what did you say? That's Water Rights Institute?
No, Water Resource Institute in San Bernardino.
Okay.
They're located on the Cal State San Bernardino campus in the library.
I think for those, we have to have a cutoff here of what are the records that were required by the statute. So and certainly I'd be very interested in records of earlier diversions. But for those, I recommend that you, either yourself or in coordination with other parties, submit those as your party's exhibits. And we'll get those into the record that way. But those could be very valuable. And if you can do that, and then of course have some testimony that we call authenticate, which explains where you got them and what they are so that we know that they're valid, then that would be helpful. But please try to do that as part of your exhibits that you submit.
Can you explain what you want by, because okay, now that just threw me on all my record sources then, like if I got them, or do I have to have, what do you want on that authentication? Now I'm like, oh no, all these, I have a lot of records.
Well, you might want to ask one of the other attorneys to help you out on this. Sorry if
okay.
I divulge into legal jargon, but basically it's just explaining what you did to get them and how you got them.
Okay.
So we know that basically you didn't just go, to some pawn shop or something and picked them up, and we have no idea what they are.
Okay.
But they're actually from a legitimate source.
Okay, thank you.
I hope that's my lawyer's simplification of authentication requirements. But that's basically just to make sure that we have some confidence that they really are, in fact, what they indicate that they are. So, okay, we're getting there. I didn't realize this was going to take so long, although I guess I shouldn't have been surprised. But thank you very much for all your patience. That is all I have for today. That's enough, I think. Does anybody else have anything else that they would like to discuss today? All right, Ms. Doty, go ahead.
Sorry, one last question, which is just, what do you envision to be the order of testimony? So I assume it will be prosecution, but then I don't under the extra parties.
Right. And I don't know if does the hearing notice talk about that? Maybe it doesn't. Let me just double check. I don't want to say something that's inconsistent with what we put in the notice. It does not. It talks about order of proceeding on page 19, but it doesn't say which party will go first. So that's a fair question. My plan is certainly for the prosecution team to go first because they are the ones who have brought this action and basically need to set forth their case. My plan then was for BlueTriton, that's to put on their witnesses and direct testimony and have them be subject to cross-examination. My tentative plan, unless somebody tells me that we should do something different, would be for BlueTriton to go second, to then put on its witnesses and so forth and have them be subject to cross-examination. And again, because they are the respondent in this matter. And then for the other parties to go after that, I didn't have a specific order in mind for the other parties. The water board normally does this, and you might think this is not fair, but it doesn't really show any preference. But we normally have the state agencies and the local go next, which in this case would be Cal Fish and Wildlife, and then the local public agencies, which in this case, I think our only local public agency is the San Bernardino Valley Municipal Water District, and then the private entities, and then the private parties. So that's my plan. I certainly am open to comments if somebody thinks we should go in a different order. And I see, Ms. McGuire, your hand is up. What is your question or comment on this?
It's a little off topic from what you're currently discussing. So if you would like, I can wait, or I'm prepared to ask it.
I don't see any other hands up, so why don't you go ahead?
Okay, it's a quick question. We would like to supplement our notice of appearance. We have one additional attorney that would like to appear on behalf of BlueTriton. Is that possible at this point?
Yeah, if it's an attorney, that's fine. I mean, supplementing witness lists is sort of a more substantial issue, but basically another attorney, I don't have a problem with that. I think you already have 4 attorneys, but that's okay. So just send me an email send me, the AHO, an email, of course, with CCs to all the other parties, and we'll add that person's name to the service list. And then, are you planning to have that person be involved in the hearing to ask questions and so forth?
I haven't had an opportunity yet to speak to this person. It is our general counsel for BlueTriton. Okay. So she may certainly exercise her right to participate more fully.
Okay, the one thing I do normally require, I mean, certainly you're entitled to have as many attorneys as you want participate in the hearing, but normally I try to limit it so that each party only has one attorney asking questions of any one particular witness. It just, whether it's direct or cross-examination. Otherwise, it just sort of gets out of hand. It, it can tend to be repetitive and so forth. So that applies to you and to the other parties. So you can have different attorneys, and it can be different attorneys for different witnesses, but I normally like to keep it to one attorney questioning each witness, one attorney for each party questioning each witness, if that makes sense.
Understood, and we will comply. Thank you.
All right, thank you. All right, it's almost lunchtime. Does anybody else have any questions? We've covered a lot. I really appreciate all your patience and your understanding on this. As I say, I'm doing as best I can to sort of thread through the needle here and try to accommodate everyone's interests as well as I can. So I will prepare a second pre-hearing conference order for the matters that need to be, that should be subject to an order, and circulate that to everyone. Of course, the AHO Lyris email list as well, and we post it on the AHO website, AHO webpage of the State Board's website, and email to all of you on the service list, if I didn't already say that. And again, just a reminder, if you have any updates to the service list, please send an email to the AHO with those, with copies to the other parties whenever you can, as soon as you can, so we can maintain an updated service list. So with that, thank you all very much. We'll plan to talk on December 16 at 1 p.m. just about the site visit, and then we are scheduled to start the hearing on January 10th. So everybody have a good day. Thank you very much.
Thank you, Mr. Lilly.
Bye.
Thank you.
Thank you, Mr. Lilly.
Thank you.